Please, my lord, I like to mention one of WPC's case number 376 is pending before this honorable court. And my lord, earlier this honorable court speaks for this case after a 2 week, but today it is 4 weeks ago. The matter is not listed. And my lord, I'm praying for listing this matter for tomorrow.
Actually, I beg to mention item number 31. But with the consent of the other side, the state of Assam, my lord.
31.
31, my
It is
lord.
for order.
It is for orders. My lord. Could it be on some other day, my lord?
Oh, no. Just a minute. Who mentioned this? This is WPC. WPC, this is to be mentioned before the senior bench. I thought it's criminal. Yes.
Well, if it could be on some other day, my lord.
When do you want?
My lord, could it be on 24th November, my lord?
Mr. P. Nair, Land Council for the petitioner, with the consent of the Land Council of the other side, prays for lifting this matter on 24th. The prayer is allowed. Please this matter on 24th. The court.
But there's an interim order, my lord.
The interim order passed earlier shall continue till the next date of this.
But item number 33 also, my lord, the other side was supposed to mention, but I don't see them.
33.
33. Said the counsel for other side, Mr. Sharma, said he had some difficulty today. He could not come.
Okay.
So
Mr. P. Nair, Land Council for the respondent.
you are, oh, the,
Oh, you're
no,
for the,
he's
you're
on
for the petitioner. Okay. There's no objection.
actually the mention would be by him. Well, he called me up that.
Okay. The senior is out of the station. Okay, Mr. Land Council, some is said is senior. The conducting council is out of the station, and therefore pray for adjournment of the matter. For how much time?
Well, on the same day, my lord.
Okay. To which Mr. P. Nair, Land Council, appearing on behalf of the respondent, has no objection.
24th November,
Okay.
my lord.
On request of the party, let this matter be listed on 24th
24th November, my lord.
November.
November.
Okay, 24th November. Okay.
Deep.
My lord, item number 30, my lord.
Item?
Well, maybe 30, my lord. On the earlier occasion, my lord, I was granted bail, my lord, by my lords, my lord. Court. My lord, tomorrow we are going to join the investigation, my lord. It is written in the order, my lord. My lord, we are just traveling, my lord. We are, my lord, if this matter to be taken by 12 o'clock, my lord, I will be able to address, my lord. After that, my lord, the flight will be there, my lord. Tomorrow, like, I will be. Yes, my lord, today it is item number 30 and I am sitting right now for the flights, my lord. Like, my lord, if it to be taken right now or after some time, my lord, I am ready, my lord. But anything, my lord, before 12 o'clock, my lord. It's a humble request, my lord. My lord, we are already on bail, my lord. And tomorrow it's written in the order, my lord, that we are coming for investigation to join the investigation before the GST officer, my lord.
You are coming tomorrow.
Yes, today only we are coming, my lord.
Tomorrow
is the date fixed. My lord, today we are coming, my lord. I am sitting right now in the airport,
you
my
want
lord.
this matter to you want this matter to be fixed tomorrow?
My lord, if it is to be heard by 12 today, my lord, I will be able to address the honorable court, my lord. If else, my lord, if it is not coming by 12 o'clock in the afternoon today, my lord, then in that case, my lord, may I be permitted, my lord, tomorrow this to be there, my lord, and this interim order, my lord, to be extended, my lord.
What happened after obtaining AV anticipatory bail,
Pardon?
interim anticipatory bail? What happened after obtaining interim anticipatory bail? Did you appear before the police?
My lord, tomorrow is the date fixed, my lord, for appearing, my lord. 24th, my lord. So we are coming today. So tomorrow we will be joining the office, my lord.
Okay, we'll fix it for the day after tomorrow.
My lord,
You want
day
this
after
matter
tomorrow, my lord.
Day after tomorrow?
My lord, I am wanting, my lord, only humble request. If this to be taken today itself, I am ready to do the hearing, or else tomorrow, my lord, after the investigation, we will come, my lord.
Today it is discussed. Why you are mentioning?
My lord, because after 12, my lord, flight will be there and I will be unable to address, my lord. As item is 30, item number 30. That's what I am mentioning, my lord.
Wait for some time. Yes,
Oblige, my lord, oblige, my lord.
My lord, may I please to mention the bail application number 91/2025, which is pending before this honorable court since 28th of July 2025. And last year on 2nd of September 2025, due to incomplete service, it was rescheduled. And now service is already accomplished. So matter may be fixed by tomorrow.
tomorrow.
Yes. Obliged.
Item number 1.
I think,
May I
what is it?
proceed?
30. One is what is it? Revision. Okay,
Item number
after one.
Lordship. May I pray, Lordship?
Yes.
My Lord, evidence before your Lordship was convicted under section 326 IPC for a period, simple imprisonment for a period of 2 years. Against the conviction order, my Lord, we have filed an appeal before the Learned Session Board. It was dismissed. And against this, my Lord, this present petition has filed. My Lord. Here, my Lord, prosecution has examined 5 witnesses, my Lord. Basically, the prosecution relies on the evidence of PW2 and one person PW3, my Lord, and also informant. The evidence your Lordship may find is page 22 onward, my Lord. This PW1 is the father of the informant. He's basically a hearsay evidence. At the time of incident, he was not there. And PW2, your Lordship may find he is the informant, the victim. The page 25. May I read, my Lord? His evidence is important. And he also don't want to pursue the matter because they belongs to the same place. They know from childhood each other. But without considering this, however, my Lord, they are considering on the gravity of offense. The offense is 306. The doctor opinion is that there is 12 stitches in
30?
the forehead is there.
Offense is
326.
326.
Yes, my Lord. That's why, my Lord, he was convicted
Yes.
for 2 years, my Lord.
Hmm.
And this basically they relies on, my Lord, PW2 and PW3, my Lord. May I read the PW2, my Lord? He is the victim. And in the ship, my Lord, last from 5 lines from above, my Lord, I become consciously or unconscious only came back to my consciousness at hospital, Dibrugarh. Before that, after causing injury, my Lord, he was riding a bike. He reached home. Thereafter, he went to hospital also. And thereafter, he said he lost an affair. May I read from the beginning, my Lord?
Yeah.
I came here as a witness in connection with my case. I know the accused since my childhood. We being from the same place, Bodumni, Mahadevpur, sometimes in the year 2012. When I was coming back with my bike after dropping my uncle, so-and-so to his resident at the same place, Bodumni, accused cut me on my forehead with a dagger without any reason. While realizing the gravity of my cut injury sustained by me, I reached home while driving. He reached home, my Lord. On reaching, I could realize that the pool of blood was oozing out of my head. Thereafter, I, along with my elder brother, seated into Max and mother, went to the police station, Mahadevpur, then to the PHC hospital. First, they went to the police station, and till that, my Lord, if it is a grievous heart, it could have not been drive the motorcycle, my Lord. After stitching of my injury and first aid, we returned to our residence. I became unconscious. That is after more than, my Lord, 3-4 hours. He reached home, he filed the FIR, went to hospital. Then,
Yes. What was the medical report? MLC?
my Lord, this medical report, this PW, this doctor was examined. This page 31. page 31 is the doctor, my lord, who under who he was treated.
Yeah.
In 2012, I was posted at Mahadev PSC as medical officer. I have been summoned by the court in connection to the injury sustained on 1 Shri Digontomes on 10/5/2012 at around 17:50 hours. Above injured person was brought to PHC.
Oh,
Mahadev
10
by
to
the-
12 inches.
Yes. Yeah, in the middle it is written, my lord, the length of cut portion was 12 to 10 to 12 inch and width of the injured person was not very clear to me, but there
It's a
was a
grievous,
gap.
it's a grievous.
Yes, my lord, according to him, it was grievous, but the
Yeah.
injury report as per the prosecution that it was not clearly mentioned who has cut. There's the, my lord, the,
The doctor has given
he is the
the
doctor.
position. Doctor who examined the injury,
He was examined.
yes,
In the cross,
he has
says,
given this
I had
statement.
my lord, in the cross, my lord, can you shift? In the cross, I had not mentioned the injured person was brought to me by the police. It is not mentioned in my injury report regarding how I had administered and treated the injured person, though I had conducted all the necessary work treatment, including the first set.
Yes, but it's appeal. No, this is revision.
Yes,
The appeal was dismissed.
appeal was dismissed, my lord.
Okay.
But now this appellate order is in page 60 onward.
So what is wrong in it then,
My lord,
according to you?
according
It's a,
to my,
you have seen,
my lord,
doctor, you have seen, you have read the doctor's deposition. It's a grievous 10 to 12 inch.
yes, my lord, for
That-
the records may be called for, my lord, the injury reports and all,
Okay.
because it is.
They have
now it is
examined
before the learned,
And then you see after examination and after appreciation of the evidences of doctor and the injury report, he was convicted.
But my lord, for that also, my lord, they belongs to the same, then the
Maybe,
informant
but then
himself also not wants to pursue the matter, because,
No,
and he was riding in a speedy bike, my lord.
maybe, but this,
If
this
he
is,
went to, if he
this
was
is not
previous
compoundable. This is not
Madam-
compoundable. 326,
320,
not a minor.
not comparable, of course.
Then
He paid before the court that they belongs to the same place, so.
immaterial.
But the learned court below, it was not considered and he was convicted. My lord, my humble submission at this stage, my lord, records may be called for, my lord, all
Yes.
matter may be heard. And I'm filing this petition, my lord, for 38 for calling of the records to examine whether, my lord, conviction was rightly done. I have got the deposition of the witnesses only.
Okay.
And if he was previously injured, my lord, how
Yes,
the
we
person
we
can
notice.
rise?
Your Lordship may issue notice, Your Lordship. However, Your Lordship, I have certain, I'll just surprise Your Lordship. At page number 15, Your Lordship will see the prayer portion.
Hmm.
Starts with 14. If I may read, Your Lordship.
Hmm.
17/12/2020 passed by the learned judicial magistrate first class NAMSA NGR case number so and so convicting the accused petitioner under 326 of the Indian Penal Code and sentenced the accused petition simple imprisonment for life.
Yeah.
This may be, yes, this may be corrected.
It was corrected.
I have not been
Where
given.
it is corrected?
In your board copy, it was corrected. It was some typing mistake.
No, which court copy?
Your Lordship.
Accused petition, simple imprisonment. It is simple
Yes, for
imprisonment.
2 years.
Hmm?
Simple imprisonment for 2 years
Okay,
instead of.
for 2 years. Okay.
Yes. It is a typical. It was corrected.
This,
I may be given the corrected copy, Your Lordship. Otherwise, Your Lordship may issue notice.
Okay.
And call for the.
My lord, notice may be called, my lord, short date may be given, my lord, records may call, my lord.
Mr. Skedori, non-counsel for the petitioner. also hire Ms. Jeannie Lanet additional PP for the state respondent. By filing this, what is this? This is not appeal.
No, this is a revision.
No, this is a criminal revision petition.
Then why you have mentioned appeal? Phase one. I thought this is criminal revision.
Yes, my lord, this is a petition under section 438.
Okay, read. First,
Oh, sorry, my lord. This is under review.
you have to correct it. See,
This is a petition. It should be instead of appeal, my lord.
correct it.
Okay, your lordship, I may be allowed to correct.
Filing this criminal revision under section 438 and 442 of the BNSS 2023. The petitioner challenged the judgment in order dated 1/7/2025 passed by the Court of Session Judge Teju in criminal appeal number 01 within bracket NMS bracket closed 2022. Whereby the appeal filed against the judgment and order dated 17/12/2022 passed by, who passed the first order?
My lord, learned judicial magistrate first class.
Judicial Magistrate First Class Namsai. Has been dismissed and affirmed the conviction. No, has been dismissed and affirmed the conviction of the petitioner under section 326 of the Indian Penal Code and sentenced to imprisonment for 2 years with fine of rupees 10,000 with default clause. Issue notice. Call for the trial court record. Since Ms. Jeannie appeared and accept the notice on behalf of the case respondent number 1. No formal notice may be issued. Of the appellant, the petitioner shall take steps upon the respondent number 2 by a register forthwith taking as well as the usual process within a week from today's start. List is matter after 4 weeks. Okay.
Because the
After 4 weeks. Okay.
you are the initial standard after the judgment.
Okay.
So it could be on after this one on 22.
22. See, since we have called for the record, let the record be received. On 22, it may so happen that the records not yet arrived. So therefore, we are putting after 4 weeks. As you know, when the record comes, they are list immediately. Okay.
On 22 October. After waiting.
22 October. Is it okay?
No issues. No issues, Your Lordship.
Okay. Please sit again on 22.
Item number 30.
My lord, may I? My lord, order.
Yes.
My lord, as per the order, my lord, it is written in the order, my lord, that 24 is the date fixed by the investigating officer of the GST, my lord. There we are going, my lord. For that, my lord, today we are traveling to Italy. My lord, the client is also, petitioner is also traveling, my lord. Then, my lord, this matter is fixed today, my lord. If it to be like taken after tomorrow's investigation done, my lord, then we will come with that. We have already joined the investigation. That's what I have to submit, my lord, in today, my lord.
What is your
If
submission?
tomorrow also, my lord, my two way of submission, my lord. One is that, my lord, tomorrow is the date fixed, my lord. 24th.
What do you
September
want? What is your
2020.
submission? What do you want now?
My lord, now, my lord, that tomorrow, today we are traveling, my lord. Tomorrow we will join the investigation, my lord. This much, my lord. We to be protected by that time, my lord.
Mr.
Afzal Ansari.
Yeah, sorry, Islamic Council for the petitioner. Some Mr. The accused has been summoned by
Lordship,
GSTCS, my lord.
Lordship, on perusal of the case study, Lordship, he was directed to appear before the IO. Interim was already granted. So till now he failed to appear, Lordship. Now he is seeking the more time. So tomorrow this matter again be listed, Lordship, as per his submission.
Oblige, my lord.
You were
Oblige,
directed
my
to
lord.
appear before the eye of the case within 10 days. What happened?
My lord, before the CGST, my lord, that I have submitted, my lord, it is written in the order that 24th September we are being summoned by the GST, my lord. So we are come 24th. For that today we are taking account.
We are not connected with that. In the bail, there is a direction that you should appear before the eye of the case within 10 days. Whether the accused appeared before the eye of the case.
My lord, tomorrow we are coming, my lord, before the Itanagar police station also and
Nana
CGST
Council,
also, my lord.
what are you saying? What we have to do with the tomorrow's your appearance before the GST? There is a direction. Kindly answer the question. There is a direction that you should appear before the eye of the case within 10 days. What do you have to
My lord,
submit in
that,
this?
my lord, in that, my lord, I have on that, they only have submitted, my lord, that 24th we are coming, my lord. That was
So
also
what?
recorded in the order, my lord. My lord, only
What?
1 day permission, my lord, only one more day, my lord.
Okay.
Tomorrow we will be.
Submits that the accused since the accused applicant has been summoned by GST on 24th,
Yes, my lord.
he could not appear before the eye of the case. By the way, where the accused stays?
My lord, he is in from West Bengal, Howrah. My lord, it is mentioned in the order's first line also, my lord. The proper address is.
Planning Council, because you said that on 24th he has been summoned. On
Yes, ma'am.
before that you will be coming, and therefore it was on your prayer only it was granted. See,
My lord, 24th we are coming, my lord. That we are saying, my lord. Again, repeated, my lord. Today we will be landing, my lord. The flight is delayed.
and why
It
you
will be
did not pray? Why you did not pray for
My lord,
granting
we were
some
in
more
the
time?
assumption. My lord, we
Because,
were in the assumption, my lord, that tomorrow is the date we were given, my lord. And tomorrow we are coming. My lord, only one more day, my lord. Tomorrow we will be there in the physically, my lord. After joining the investigation, we will be there, my lord. In the court itself, my lord.
Lana Council for the petitioner submits that the accused petitioner is resident of Kolkata, West Bengal, and
Howrah.
he has been summoned to appear before the GST office on 24/9/2025, for which he is arriving. You are arriving today?
Yes, my lord, today only, my lord.
Okay, today, therefore, pray for extension of the appearance before the IO for one more day. The prayer is enough. List is matter. again after,
Then day after tomorrow, Lordship, because
again after 2 weeks.
Lordship,
Pleasure.
Lordship, here Lordship, interim was there, Lordship. That's why Lordship only day after tomorrow, Lordship. Because today they are coming, then tomorrow if they have makes their submission, then
For 1 day.
that's why Lordship.
Okay,
Day after
the
tomorrow,
prayer is allowed. Okay, list this matter again on
day after tomorrow,
day
Lordship.
after tomorrow.
Yes, Lordship.
You are with the case diary.
Yes, Lordship. I
Okay.
have case study, but only statement is required, Lordship.
Okay.
So, Lordship, if they are coming today, Lordship, then tomorrow, if they will give their statement, then day after tomorrow, I'll produce that
My lord,
statement.
today
for
only
report.
if the flight is, everything is okay, my lord. Today we are arriving, my lord. Today in the evening we will appear before the Itanagar police station, my lord.
Then
That is
tomorrow,
the
then,
case, my lord.
Lordship.
Tomorrow.
Yes, Lordship.
And tomorrow GST, my lord.
Yeah, day after tomorrow. Okay.
Yes, Lordship.
Okay. The prayer is allowed. List this matter again day after tomorrow.
It's 25, Lordship.
On 25. Okay.
Obliged, sir.
Obviously. Highly obliged.
Item number 2,
Yes.
Well, challenging this mail order, my lord is aware,
Yes.
the mail order has to be conducted and the judgment has to be rendered in the open darbar. Here what had happened is, the village authorities, they conducted the mail, my lord, and then they forced for a settlement, which is not permissible under the law. My
Is
lord,
it a
the-
mail?
Yes. So, my lord, the locus of the petitioner is that she purchased a plot of land. My lord will kindly come to page 22 street. My lord, this small correction, typological correction is there. That this is on 30th August. The settlement, the gift deed, which I have purchased the land. Be that as it may, my lord, that's I have purchased this land, and thereafter, my lord, what had happened is, I have been in occupation of this land for long. So then, accordingly, the road was to pass through my land. So BRO appointed my son as the contingency staff that my lord will find that page 24 to series 27-9. Just I'm showing for a purpose, my lord.
This is.
Hmm.
What certificate is this?
This certificate that so and so, resident of so and so, Damin Circle is absolute and sole owner of the land located.
Okay.
So this is issued by the HGB. So then thereafter, my lord, I have been in continuous possession of this land for long, and which my lord will find as
This you purchased it. Okay, 2002.
yes, my lord, executed on 23,
Okay.
2019.
Okay.
So page 24, my lord will find
This certificate was issued by HGB.
HGB certifying that land is in my continuous
Okay.
possession, my lord. So now next page, my lord, 25.
Hmm.
Is issued by one SK Yadav, A civil of the BRO. Because the land, the road has to pass through my land. So in lieu of certain things, they have appointed my son. So which is still in working law. Now, the dispute arose on 2/9/2024, my lord,
Hmm.
which my lord will find that a declaration was issued by the Secretary Land Management Government of Arunachal Pradesh. My lord will find at page 26 for constructions of the Trans Arunachal Highway there.
Okay.
So
So you
anyway,
are challenging which one?
no, I'm coming, my lord. Just
Okay.
I'm.
Hmm.
Then my lord, what had happened? This my name is appeared in order to establish my fact that I am the owner of
Okay,
this
okay.
land. Just kindly see then thereafter what had happened. Once that final award of the
This
land comes
declaration was done by whom?
by the Secretary Land Management to acquire the land.
Hmm?
Secretary Land Management to acquire the land.
Acquire your land
Yes.
for,
For construction of the road,
okay,
Frontier Highway, my lord.
okay.
So thereafter, what had happened is my name appeared at serial number 183 But later on, what had happened, it was deleted from the list. And the private respondent was included. Now, this was done only because of the mail notice. The mail was held, my lord. My lord will kindly come to page 53 for a moment, my lord. Type copies. This notice was issued, then that mail order was at type copies at page 54, my lord, for legibility.
Yes.
This
Customary.
the apex customary court of district. My lord, when I see this particular thing, this apex customary code defined under section 2, my lord, probably may not have the jurisdiction for one reason, my lord. Firstly, after coming into force of the Civil Code Act 2021, my lord, the village authority having the pecuniary jurisdiction is supposed to settle the land. And thereafter, if there are two villages involved, dispute involving two villages, then only the apex court can take the charge.
Yes.
So there's the first thing, my lord, that I noticed. Probably this is not sustainable. In law.
The complaint was lodged by you.
Yes, my lord. Because that fellow was,
You lodged complaint before.
I lodged complaint. So, my lord, kindly see page 50.
So where is the complaint?
Yes,
Where is the complaint?
54.
No, 54 is, I think this is mail order.
Mail order.
No, your complaint.
Complaint.
You addressed to him.
Complaint we have not. Sorry, my lord. Complaint has not been annexed. The only order is there, my lord. In any case, my lord. Verbal complaint. Well, kindly see, let us peruse page 54.
Yeah.
18.4. Whereas a complaint has been received from Srimati so-and-so, wife of so-and-so, Ranjit, wife of so-and-so, Blaze Maruk, P.O. Damin, P.S. Coloring, Kurung Kumar district of Arunachal Pradesh, against to one Waruk Dobin, late Waruk Talar, to Sri Saleh Sandhu, late of so-and-so, 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 Damin, P.S. Coloring district so-and-so, in connection of land dispute case, namely land Khami near 39-kilometer BRO road to Damin to Guni Administration of Justice, Regulation 1945. Herein, I don't know this, to as the principal regulation from the date of commencement of the Act recollect. Therefore, the following all Kurungkume Gangbura Welfare Association are hereby appointed for trials and settlement of the case as per customary law. Well, I'm pausing for a moment again, same question. See, under the AFR per se, after its amendment, the Civil Code Acts, well, these Gangbura associations are not a recognized forum.
Not the association.
Not the
This is
association.
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 This
Because-
Gangbura Welfare Association.
Correct, my lord.
So that is why I'm curious to know what is your address, your complaint.
Yes.
It was addressed to whom?
It was chairman. Anyway, my lord, that's that part. Chairman of the village authority, head Gangbura. My lord, I explain two counts here. Normally, in our village councils, village council, my lord, we do two things, my lord. One, the verbal complaint is also enough. Another is written complaint, my lord. Section 44.
Yes.
So this has not been complied with. The prima facie minority from this mutual settlement agreement. And you cannot deduce power which is not vested by the law, my lord. So therefore, this impugned mail settlement, my lord, will find at page 55, my lord. Instead of deciding the title rights ownership of the litigants,
This is a settlement. Robert.
this is settlement, and which they do not, which they
It
cannot
ap-
do
it
it.
appears by this settlement, it appears that both the party agreed.
Yes,
And then both the party have also put their signature.
yes, my lord.
And then, okay, again, the judge one, judge two,
Yes.
GB has signed. But then here, not in the capacity of the member of the association, but as a head GB.
Correct, my lord. There is a conflict of interest. So therefore, this cannot be sustainable in law, my lord. So then thereafter, my lord, what had happened
But
is,
just, but it appears that this is on agreement of both the parties that appears. Because both has put signature, you
Yeah.
also, and the opposite party also, it appears. Settlement agreement, it says settlement
No.
agreement,
yes, but
not the order.
no, not the order. My lord, what had happened was,
Hmm.
the mail was supposed to be conducted in the open darbar.
Yes,
This
this
was
is not a
not
mail settlement.
they did not conduct it.
Hmm.
So later on, they said ki they will pass the order, and resulting into this impugned mail settlement order.
But why did you put signature if you are not agreed with the settlement?
That is one aspect of the case, my lord.
Yeah.
But I was fully aware that this question will fall from my lord. My answer is, my lord, I am challenging on the procedural aspect, because once the act says that under section 44(1), you are bound to conduct the mail in the open darbar and then pronounce the judgment, thereby deciding the title this way or that way. But here is a case you have not followed the procedure, my lord. So procedure, if explicitly it is provided in the act, if you do not follow, then any action you do is a nullity, my lord. In the legal parlance, we call as void ab initio, my lord.
Yeah, that is there. But here, this settlement looks more like the mutual settlement.
No, that's why, my lord.
It's mutual settlement only. The following points are being agreed both by, agreed both the
Correct.
first and the second party. And
Correct.
the title itself is not any order. It's settlement agreement.
Correct,
It's
but
not a
that's
mail order.
not a mail order. That's
It
initially
appears that out of this mail proceeding,
they have done
come out and they have done it by way of settling the matter out of,
which they are not supposed to do.
okay.
That's why, my lord, I said section 44(1). I have made a verbal complaint.
Mail order.
Under section Your Lordship, I may be allowed to read out the content.
Yes, yes.
Your Lordship,
The person was arrested.
sir, on 7/4/2025, at 14/4, I received a telephone
What is the section? 21B,
21B,
27A.
27A. Your Lordship, the CC has already been taken up. During the CC, 2 section has been dropped.
Okay. So charge sheet filed already.
Yes, Charge has.
How? Okay, charge sheet, yeah. Which section was, he has been charged under which section?
Only section 21B is made out, Your Lordship.
Okay,
Charges.
and then 27 and 29, 27A and 29 drop.
Drops you.
Okay. Then, so did you apply? Right court?
Yes, Your Lordship. Before the session court, the first bail was applied, however, it was rejected. Your Lordship, I have not enclosed the
When?
rejection bail order, Your Lordship.
Where is?
Yeah, I have not enclosed the rejection bail order because, Your Lordship, till that, Your Lordship, the rejection order has not been prepared. It was orally, Your Lordship, on the
Where have you stated?
para 12, page number 9. That the applicant begged to state that earlier the applicant has filed a bail application before the special judge NDPS UPI BA number 382/2025. However, the same has been rejected by the special judge.
When?
It was rejected on 13 of August. Now
Where have-
2
where
months is
have you stated?
counting.
Where have you stated?
Yeah, subsequently, the bail application same has been rejected. Your Lordship, here I have made. However, the same has been rejected by the special judge UPI.
When?
Your Lordship, 13, Your Lordship.
Where do we find?
Your Lordship, specifically, I have not mentioned it in the petition, Your Lordship.
See, you have to mention, and then the order given, you have to annex, and not given, you have to clearly state. Order, although you have applied, if you have applied, you have to annex that application for CPC.
Now, Your Lordship, if you find the Your Lordship, I have not enclosed the annex the charge
See,
sheet, Your Lordship.
Those are the basic documents you should file. If you are seeking bail, those are connected order. Yes. Regarding bail, that you have to inform the court what you have tried, what was the last order, and what if not given, you have to state clearly, although you have applied. Yes, Your Lordship. It was not furnished. What do you want to, by giving half information?
Your Lordship, kindly, Your Lordship, TCR may be called for Your Lordship, because in the TCR, Your Lordship, the bail rejection order will also be available, Your Lordship. And the date would also be mentioned here.
So thereafter, after rejection of bail, only the charge was framed.
On the same day, it was rejected. Same day, subsequently, the hearing on charge, bail application was taken up. After framing the charge, the bail was rejected.
After framing the charge,
After framing the charge, the bail was rejected.
we would like to see that bail order.
Your
Why
Lordship,
rejected?
immediately after, Your Lordship, after the rejection, I have applied for the rejection bail order. However,
Where
I
is
could
that?
not obtain.
Where
Your
is
Lordship.
that? You have to show that it was applied, not furnished. Yes,
Yes, Your Lordship, in fact, I would suggest if they withdraw, because there is no charge sheet as submitted that charge sheet, the case was charge sheeted, Your Lordship. In the CC, there, some of the sections where he was discharged of some should not been annexed.
where is that order? Have you annexed that order?
No, Your Lordship.
And
See,
there is no GR number of the case. We are not aware of in which court the matter is pending and under which GR number the case is on trial, Your Lordship. Nothing as such is
Where is, what
available
is
in
the
petition.
case number in the, before the court? Where have you stated?
Your Lordship, before the session, special judge, the case is being taken up as Itanagar PS case number 55/2025.
That cannot be. After charge, sheet, you say that charge sheet was filed. Charge sheet already filed.
Yes, charge sheet file.
Case taken cognizance of, registered before the session court, special court and DPS. Where is that number? Which case is to be called for? Which record of which case?
Your Lordship, I may be kindly allowed to withdraw this application and
Why should you rush without preparing? Mr.
time comes on.
Planning Council for the petitioner wants to withdraw this bail application with liberty to file afresh after making accept. This bail application is dismissed on being declared. Dismissed, huh? On being withdrawn. Okay, with liberty as declared.
All right.
Item number 4.
Yes. Yes, what is it? With the birth?
Yes, Lordship. Lordship, I have filed this criminal petition to invoke the inherent power of this honorable court to quash and set aside the impugned order passed by the learned Court of Judicial Magistrate First Class, Pangin, wherein the cognizance has been taken against the petitioner without following the procedure laid down under the BNSS of 2023, Your Lordship.
Okay.
This is a complaint case wherein, Your Lordship, this private respondent has lodged a complaint before District First Class by alleging that he had lodged FIR before the police, but police did not register the FIR. Then he had approached the superintendent of police. Then the SP also did not entertain his complaint. Then he has approached the magistrate under provision of 173 clause 4 of this BNSS, Your Lordship.
What is that?
Your Lordship, this is
Issuance of direction.
Yes, information
Officer
is
in
to
charge.
non-cognizable cases and investigation of such cases, Your Lordship. Your Lordship, this complaint filed by the private respondent, I have enclosed here with, Your Lordship may find, at phase 40, Your Lordship.
What is on page 40?
Phase 40, Your Lordship.
Complaint.
Yes, Lordship. Lordship, here this complaint has been filed under section 173, clause 4. Read with section 175, clause 3 of Bharatiya Nagrik Suraksha Sanghita 2023, Your Lordship. Herein, Your Lordship, the complainant, the private respondent has prayed the magistrate to issue direction to the lying police station to register FIR against the petitioner, Lordship. Lordship, here, Lordship, the law is very clear that when a person lodges FIR before the police, but the police do not register the FIR, and then the SP also do not entertain the FIR, then the person can file application before the magistrate for the instruction, Your Lordship.
Yeah.
So that is given under 173 clause 4 of this Bharatiya Nagrik Suraksha Sanghita 2023, Your Lordship. Dear Lordship, this section 175 clause 3, Your Lordship, section 175 clause 3 made very specific and mandatory that when any such complaint is received under section 210 of this BNS, application made before the magistrate, then the magistrate shall make an inquiry. Then after hearing the submission of the police officer, then only he will decide whether the direction should be given or not, Your Lordship. Here, Lordship, in the impugn order, the magistrate is very clearly
After hearing whom?
police officer, Your Lordship. After hearing the police, Your Lordship. And Lordship, I am reading the section 175 clause 3.
175.
There you go. Your Lordship, earlier in the CRPC, this provision was not mandatory. Under CRPC, Lordship, it was a discretionary act of the magistrate. That after hearing the application of the complaint, it was upon the discretion of the magistrate whether to give an instruction or not, Your Lordship. But after this enactment of BNSS, Your Lordship, it has been made mandatory that the submission of the police
Yes,
has to be heard, Your Lordship.
173.
175, Your Lordship.
Sorry, 175.
Clause 3rd, Your Lordship.
Okay.
Lordship, I am reading, Lordship.
Yeah.
Any magistrate empowered under 110 may, after considering the application supported by an affidavit made under subsection 4 of section 173, that is the application that the private respondent has made in this case, Your Lordship. And after making such inquiry as he thinks necessary and submission made in this regard by the police officer under such an investigation as above mentioned, Your Lordship.
By this impugn order, the impugn order is,
1/7/2025, Your Lordship.
okay, by this impugn order, what did the magistrate do?
Your Lordship,
order was
before
passed?
coming into, Your Lordship, before coming into the impugn order, Your Lordship may kindly see page number 62. That is the first day when this complaint was taken up before the magistrate. Your Lordship, at page number 63, the continuing page,
as paragraph 1, 2, at fourth paragraph from the top, your lordship, the magistrate has very clearly reflected in the order. Lordship, I'm reading. Perusal of the complaint and FIR reveals commission of cognizable offense. However, as mandated by subsection 3 of section 175 of BNSS, this court deemed it fit to hear the officer in charge of Kaing police station before issuing any direction as prayed for. So magistrate has very clearly mentioned and reflected in his own order that the submission of the police officer is to be heard, your lordship. Then, your lordship, the impugned order is at page number 27, your lordship. Lordship, may kindly see page 27.
Yeah.
Here, lordship, the police officer did not submit his report, the reason better known to him. And it has been also reflected by the in the order.
So what was the direction in this?
Yes.
In the first order?
In the first order, your lordship. Direction was
You have
given.
taken steps upon the officer in charge.
Yes, sir. The complainant shall take step along with a copy of complaint upon the officer in charge,
Where
Kaing
is that? Where is
police
that?
station within 3 days from
Okay.
today.
Where is that?
It is the page number 63, bottom paragraph, your lordship.
No, that is there, but you have taken steps.
Your lordship, I am the petitioner. I am the accused in this case. Your lord.
Okay.
This complainant
Okay,
is the
yes,
private.
Okay, thereafter,
Hereafter,
the next order is this, the present impugned order.
yes, lordship. After that, your lordship, next is on page
Immediately
number
after that,
65.
It was in the month of April.
Yes, lordship.
So after that, this.
May. It was on April. Then the next date was on January, February, March, May, at page number 65, your lordship.
Okay, there are some more order.
Yes. Officer in charge of Kaing police station did not turn up. However, he has submitted a letter whereby it has been informed that due to his schedule before the court of learned JMFC, Ying Kyung, he is unable to appear today and has requested for fixing another date. This was the order of the JMFC, your lordship. And then this impugned order was passed, your lordship. Impugned order is at page number 27. Your lordship. Lordship, page 27 is the impugned order, first page, and your lordship, the continuing page is on 28, page number 28. Lordship, at the second paragraph from the top, I am reading, your lordship. On perusal of the complaint, petition, and documents annexed, it is evident that the complainant has disclosed in commission of cognizable offences. Notice was issued to the officer in charge, Kaing, but he has failed to appear or submit any explanation for not acting upon the complaint. And in exercise of power conferred under section 174, 73, clause 4 of BNSS, 23rd, this court is satisfied that the prima facie case for cognizable offense is made out, and that police intervention is warranted. So this order clearly reflects that the report of the police was not taken into consideration on that day when this impugned order was passed, because such report was not furnished by the police, your lord.
Okay, what happened thereafter? The police has registered a case.
Or till, as per my information, your lordship, till that this FIR has been not registered, your lord. Because lordship may come into page 29, the third continuing page. At the top, your lordship, here it is written that submit a progress report before this court on or before, but no date has been mentioned.
Where?
Page 29, your lordship, at the top line, third paragraph. While passing this impugned order, your lordship, the learned court of judicial magistrate first class, Pangin, has even not mentioned the date, your lordship. It is only said that submit a progress report before this court on or before. and thereafter this case was disposed of.
So thereafter, what happened?
And
After this?
thereafter, Lordship, the offenses in which this cognizance has been taken, Your Lordship, is section 324 clause of BNS, Bharatiya Nyaya Sanhita, then section 329 of BNS, and section 352, Your Lordship.
Where, by which order?
This impugn order, Lordship.
By this impugn order?
Yes, Lordship.
Where are you reading?
Lordship, because here,
Page? Which page you are reading?
Lordship, here the this in the impugn order, the sections has been not clearly mentioned, but
Then,
here, Lordship, the instruction has been given to register the complaint dated 28/3/2025. The first FIR, which was lodged before the police station, instruction has been given FIR, Lordship. So in the FIR, Your Lordship, it has been mentioned by the private respondent that under these sections, the case may be registered. And in the complaint also, Your Lordship, the complainant, that is the private respondent, has prayed to take cognizance under these offenses, Your Lordship.
no, where
So,
is the order by which the Nanaka court has taken cognizance?
Your Lordship, here specifically the section mentioned in the FIR,
Okay.
in the order sheet, but here, Lordship, in the very first paragraph of this impugn order, the effective order,
Where?
page number 28, Your Lordship.
Hmm.
Accordingly, the officer in charge Skying is hereby directed to register an FIR on the basis of the complaint dated 28/3/2025.
It's not equivalent to taking cognizance.
Yes. Here, in the very first order, Your Lordship, when this case was taken up before this magistrate, here, Lordship, this
On the basis, only direction to register on the basis of the complaint and investigate what is wrong in it.
here, Lordship, actually these sections are actually do not attract in actuality, Your Lord. Because here,
Whether attract or not, the IO will decide now. If not attract, you register under some other section.
Your Lordship, in the complaint of
Some other offense, the which one, the lighter offense? What was the allegation?
allegation,
Now its allegation is in the complaint.
now let this allegation is there, Lordship.
Complaint was forwarded along with this,
Yes, sir. In-
and the IO will register
Here, the actually, Your Lord,
and then
yes,
investigate. And after investigation, again, he might file final report also. Then,
Your Lord, actually, here the case is, Your Lordship, that since 2009 to 10,
Hmm.
There is a land dispute between this petitioner and the private respondent.
that is
pending in the
what
court.
what I'm saying.
Yes, Lordship.
If the IO, because it's only direction to the IO to register,
Yes.
yes, and investigate. IO, we do not know under what provision of section what section the case will be registered. And after investigation, might not file charge sheet, you might file final report. Why you are so apprehensive of this?
Your lordship may come to page, please come to page
Let-
62, your lord.
Page,
62.
what is that?
This is the order of the Judicial Magistrate First Class Lordship, passed on 29th April 2025, your lordship. Here, lordship, it, very clearly mentioned by the magistrate, this
No,
complaint has
this
been
is-
filed.
See, this will also know, because now the IO has been given liberty to register. So on perusal of the complaint only, from the complaint only, the IO will register as per the section which is attracted against the accused. Not specifically directed, nor taken any cognizance. I think it's,
Here, lordship, the complaint
I
was,
think this petition is premature.
lordship, here actually this complaint was lodged by the private respondent, praying
Yes.
the court to take
Yes.
cognizance under these sections. It has been very clearly reflected by in the order also.
But cognizance not yet taken, what I'm saying, not yet taken.
Your lordship, but after allowing that complaint filed by the private respondent,
Not allowed. It was only forwarded to the IO of the case only to register under the appropriate provision of section.
here lordship may, here it is your lordship with the impugn order. It is very clearly written that on perusal of complaint petition, and it is evident that the complaint has been disclosed, commission of cognizable offences.
Cognizable offense.
Now that
if-
complaint was lodged before the magistrate to take of cognizance under particular offences, your lordship. Now admitting of that complaint by the magistrate, your lordship, by admitting that complaint by the magistrate, it draws a conclusion that the offences claimed by the complainant has been allowed by the court. Your lordship, that will be the understanding of the police officer, your
No.
lordship.
See, here is the case where the FIR, the respondent was not registered, then filed before the SP, that was also not, the SP also not directed, thereafter he came to court, and then the court only said that it appears that cognizable, there allegation of commission of cognizable offense, and that is why the IO directed to register, and didn't say any, didn't indicate any section, only says that register a case and investigate. Is it not too early?
Lordship,
Premature.
here, the fact is that now,
Let the IO register case. If
now,
you are aggrieved,
now the
then
IO
come
is
again.
registered or not, that up to date, I have no clear knowledge, your lordship, in that way. But
That is why-
my concern is that, your lordship, that judicial magistrate
See-
first class has
See,
issued an
investigation
order.
not yet case, not yet FIR, not yet registered, not yet investigated. How do you know? You will never know. Let them register, let them investigate, and if you are aggrieved, then come. It's premature.
Lordship, here my submission is that
Court
now
has
this
done
court
nothing.
has, the court of judicial magistrate first class has issued direction to the police to register the case. Now my,
Yes, you don't want this direction, you don't,
Now,
you
I
want
am-
that there shouldn't be any direction by the court to register the case.
Court-
IU refuse, SP refuse, what the court will do? What this respondent will do? He will go
here-
approach the court only.
here lordship, if the court had listened to the submission of the police, your lordship, then the fact had been,
Police did not appear, and then police did not appear. That is why only directed and given opportunity to the police twice. And there is no compulsory, you see.
lordship, if this case is registered, your lordship, I will victimize you. I am a
How?
company employee, your lordship.
Hmm?
I am a company employee, and this police will register the case and I will be arrested, your lordship.
Yes, definitely, if you have committed
But
offense,
Now, your lordship, would we
then
see
you can-
the,
you
now-
can approach the court for if you are apprehensive. of
lordship,
your
if we
arrest.
see the allegation in the FIR, lordship, it
Hmm.
is totally baseless, because basis what I am saying, not on the fact, your lordship. The allegation is that I have trespassed upon the land. Now, your lordship, since the last 15 years,
See, IO also, if there is no case against you, IO also will not register case against you for the offense which you have not committed. And even if it is registered also, IO will know that whether you, IO will conduct preliminary inquiry, and thereafter he might or might not arrest. And if you are apprehensive of after the registration, if you come to know that the case has been registered, and if you think that you have committed non-cognizable offense, then you can approach the court seeking anticipatory bail. If you have not committed, why you are worrying about it?
And your lordship, now for passing this impugn order, your lordship, procedure has to be followed, your lordship. So my prayer to this honorable court is that, your lordship, there may be merit in the case or not, but the fact is that the court has to follow the procedure. Laid down procedure was not followed. My prayer is that, lordship, notice may be issued for setting. My prayer is-
Whom notice is to be issued? Now it has forwarded to IO.
So I have filed
Complaint was already forwarded to IO. Whom the notice is to be issued according to you?
the case record of this court may be called, your lordship, because
Case record, you have annexed this order.
Yes.
This is an impugn order. Nothing has proceeded till now.
so my petition is in file, your lordship, to quash this order, impugn order, lordship.
Lordship,
This order may be quashed. That is my prayer.
Yes,
Lordship, this, actually, Lordship, we are only non-registration of FIR and it's being filed before the magistrate, Lordship, and it's being, Lordship, allowed, because registration of FIR is mandatory, Lordship. So it's already allowed, Lordship. There's no use of not issuing notice any longer, Lordship, in this petition, Lordship.
Okay, I'm passing the order. Okay.
Have a nice day.
May it please your lordship.
Yes.
My lord, I am sorry for making a mention at this hour. My lord, there's some urgent matter, my lord. This writ petition 467 was listed before the court number 2 in the morning at item number 2. But however, Justice Atta has recused himself. This is a matter of Public Service Commission matter. The lordship will know. There was an advertisement for the Arunachal Pradesh Engineering Services. So, my lord, there were, in fact, 7 posts were there. Out of the 7 posts in civil engineering were qualified for all the 7 posts. Of the 7 posts, in 3 agricultural engineering graduates were also qualified. So for that, there's about 136 posts. They had to take a ratio of 12:1. They did not do it. 362 names were included in both the list. So accordingly, this honorable court, by order dated 3rd of September, directed that everybody should be allowed to take part in the exams. That was not everybody, but writ petitioners only. Only 49 writ petitioners were there. Now, ultimately, against that, the review petitioners have been filed by the Public Service Commission, saying that of the 49 petitioners, only 22 comes within the zone of consideration, 27 does not qualify. We want to give all the 362 candidates a chance. Now, review petition, before filing the review petition, they took a decision to reschedule the exams. Now, there are 1,200 candidates who have been preparing for the last 2 months. On 18th of this month, they declare additional 346 candidates, giving us only 7 days. So we are praying for extension of time, madam. That is the writ petition. We will kindly
You are
list
for?
it tomorrow. For the petitioners, 346 candidates, newly declared on 18th.
It is the only candidate is coming before the court. Not
Those
the-
candidates whose names were declared only on 18th of this month, 4 days back.
You want extension of the,
Yes. I will so, it totally comes under the Wednesbury's principle of unreasonable.
now.
They will list it tomorrow, my lord, not
Okay.
tomorrow.
Okay.
Obliged.
Yes, your petition is premature.
Yes, lordship. Then your lordship, I may be allowed to withdraw with
You want to
liberty.
withdraw?
Yes,
That is
Lord.
better. It's
Yes.
premature only,
Yes, lord.
because no cognizance, nothing.
Yes.
Mr.
Keta, sir.
Planning Council for the petitioner wants to withdraw this petition. This petition is dismissed on the withdrawal. Okay.
Yes.
Like,
Item number 5,
May I please, madam?
My lord, in this case, the core issue and the contention of the petitioners are that the Horse jurisdiction, my lord, the learned judicial magistrate first class Tawang has taken cognizance of an offense without considering the fact that there is an embargo under section 195 of the CRPC. In this case, my lord, initially FIR was lodged, and accordingly the FIR has been culminated into charge sheet, and subsequent thereto, my lord, the cognizance has been taken. Now, if I may take my lord to the FIR, page number 46.
Okay.
This is the FIR, finally.
Page?
46.
Yes.
First information report on missing of tender papers from tender box from the Office of Water Resource Department, Tawang. As cited in the subjects above, I am to inform you that with deep concern that on dated 24th July 2025, this office had to open a bid tender at 3 p.m., but it had cancelled already due to technical error. Following the cancellation of the said NIT, all the bidders were called at 3 p.m. to collect their submitted bidding documents to this office. But with utter surprise, it was found that after opening the tender box, all the bidding documents were found missing, both technical and financial bid, including earnest money deposits. Therefore, I am to request you to kindly investigate into the matter according to the relevant sections of law. This for your kind information and necessary action, please, my lord. Accordingly, my lord, FIR was registered under section 303 of the BNS, which is theft and a cognizable offense, my lord. Accordingly, investigation was carried out, and eventually, my lord, the same has been culminated into charge sheet. Now, if my lord may kindly have page number 47, the next page is the charge sheet. The charge sheet was filed on 7/9/2025, my lord. Now, relevant part of the charge sheet would be at page number 66, my lord. 166. If I may read from the second paragraph. Under the above facts and circumstances, a prima facie case under section 221/351(2) of BNS is well established against the alleged accused person, namely so and so, so and so. These are the names of the alleged accused person, my lord.
How many accused persons?
Altogether 12 accused, my lord, alleged accused. After completion of the name, my lord, for obstructing public servant in discharge of public function and for threatening the complainant in his chamber instead of earlier registered under section 303 BNS, I send them to Honorable Court to face trial under the above aforesaid section of law. The witness mentioned in the column 13 may kindly be summoned to prove the case. Initially, my lord, when the FIR was filed, the section 303 was incorporated in the FIR. And thereafter, while filing a charge sheet, section 221 and section 351(2) of the BNS. My lord, 221 BNS deals with the obstructing public servant in discharge of public function, which is akin to section 186 of the earlier IPC, my lord. And 351(2) BNS is a criminal intimidation, my lord, intimidation, akin to section 506 of the IPC.
Two
221 BNS is obstructing public servant in discharge of public function, my lord, which is akin to section 186 of the IPC.
Okay.
And 351(2) BNS is a criminal intimidation, akin to so and so. My lord, thereafter, subsequent thereto, my lord, on the basis of the charge sheet filed,
okay, 506.
my lord,
Okay.
on the basis of the charge sheet filed by the IO, my lord, the magistrate on 11/9/2025 has taken cognizance under section 221 as well as 351(2) and accordingly issued summon to the alleged accused person. If my lord may kindly have page number 69.
Yes.
If I may read.
Yes.
Seer put up today upon submission of charge sheet under section 193 of the BNSS in the instant case. Perusal of the charge sheet along with the materials annexed there, it reveals that although the FIR was initially filed for an offense under section 303 of the BNS for theft, after the investigation by the concerned IO, the charge sheet has been filed for offenses under section 221 and 351(2) of the BNS, which is non-cognizable in nature. However, in my considered view, the permission of the court is not required when the FIR and the investigation is conducted for an offense which is cognizable in nature, even if the charge sheet is subsequently filed under non-cognizable offenses. Accordingly, upon considering the material on the record, I find sufficient material to proceed against all the accused person, and hence cognizance of offense under section 221 and 351(2) of the BNS is taken against the accused person, namely so and so, madam. Now, if I may take my look to the BNSS one.
Right. So,
The only contention of the petitioner is that the learned judicial magistrate first class ought not to have taken cognizance of the offences which has been mentioned here, since there is a clear embargo under section 195 of the CRPC. There has to be a complaint in writing before the magistrate. Any FIR which has been culminated into charge sheet, the magistrate cannot take cognizance. It would be void of initio, my lord. And it will vitiate the whole trial proceeding. At best, the complainant ought to have filed a written complaint before the concerned magistrate for taking cognizance of the office. That is the procedure, my lord.
now, what was the procedure left for?
In this case, my lord, FIR was filed, carried out the investigation, culminated into charge sheet, and thereafter, on the basis of the charge sheet, the magistrate has taken cognizance. And this has been barred under section 195. There has to be a direct complaint in writing before the magistrate, my lord.
Now, what according to you, the magistrate should do next?
My lord,
After-
magistrate has no power to take cognizance. No power to take cognizance. The whole trial is vitiated, my lord. If my lord may kindly have the
Yes.
BNSS. 215 of the BNSS. My lord has it.
215.
My lord. Prosecution for contempt of lawful authority of public servant for offences against public justice and for offences relating to documents given in evidence. No court shall take cognizance of any offence punishable under section 2062, 223. Now, in this case, my lord, the offence they have incorporated is 215 of BNSS, my lord. BNS, sorry. 221 of BNS, which falls within this parameter, my lord. Both inclusive but excluding section 209 of
21.
BNS 2023. Or of any abatement or attempt to
221.
commit. My
And then whatever is 351.
351, my lord, these are so closely connected and arising out of the same transaction, my lord. Therefore, it will also be governed by section 195
Yes, ma'am.
of the CRPC.
Yes.
So therefore, my lord, my only contention at this stage, until the TCR is being called for, my lord, further proceeding till the returnable date may kindly be stayed.
Yes. Lana PP.
Well, since there is embargo lordship in 215 lordship, after the completion of investigation and filing of charge sheet lordship, the embargo come into play, lordship.
Mr. Shiv. JT, huh?
My lord, Jaysri Key.
Yes, sir. How name change?
Key, I have used my title, my lord.
Okay,
In fact, there are two Jaysri, that's why there's some confusions.
okay. You surrendered.
My lord, I have surrendered and I've used my title.
The J sharing you have surrendered. Okay. JCK, okay. E. Also hard, Mr. Lana PP, huh? Start. This is an application file under section 528 of the BNSS 2023. There is a respondent also.
No, man, only statement,
Okay. We'll see the record there.
my lord.
Okay. challenging the order dated. Order dated
Order dated, my lord, 11/9/2025.
11/9/2025. Class 5. The Court of Judicial Magistrate, first class. Tawang.
Tawang, my lord.
In GR case number 14/2025. Arising out of which PS case?
Tawang PS case number, my lord,
Tawang PS case number
8 of 2025.
2025 under section. This is
In the section initially it was 303.
okay, 221. Stroke 351 within bracket 3 of VNSS 2022. Whereby the Learned Court has taken cognizance of the offense under section. Okay, for use of the offense under section 3. No. Two 21, so 351 2 of VMSS. Oh. Stop, huh? This will not this. Call for that, file for the case. So since Mr. Learned PT has appeared and accepted notice on behalf of the state, no formal notice needed. Please this matter
After 2 weeks.
after 2 weeks. Okay.
Lord, please, in the meantime, my
In the
lord,
meantime, the operation of the further proceeding
Well.
of the GR case number so and so shall remain still.
Scan copy, lordship, scan copy, please, your lordship.
Scan copy?
Yes.
Scan copy. Huh?
Definitely.
grateful.
Item number 6.
Still returnable date. Huh? Still returnable
May
date.
it please your lordship.
Yes.
Lordship, this petition is filed for quashing an FIR, my lord, date 23/5/25, my lord. Lordship, may kindly see for the FIR, my lord, at page 42. Page 42, man. May I read, my lord?
Yes.
Page 42. That sir, above mentioned person so and so repeatedly seeking financial help from me with so many verbal promises, assurances during the month of April, May 2023. Hence, due to his persistent pursuance, I succumbed to his pressure and entered into a money agreement in the form of declaration dated 2/5/23 in presence of competent witness, namely so and so, with a promise to return within 1 month. Failing which, he promised to pay 4% interest per month, my capital amount, that is rupees 15 lakhs only, and the same was notarized on the same day. That, sir, I am the victim of being good. I loaned him on good faith so that he can flourish in his business or build out himself from the problems. But alas, he is nowhere to be found and avoiding my calls, and now he have blocked my numbers and absconded. Lordship, this is the basically relevant part, that money agreement was there and loan was, financial assistance was taken by the petitioner. This is an
What is the
admitted
register
fact, my lord.
section? 420.
Yes, my lord. 420/406, my lord.
Private loan only.
Yes, my lord.
Where is that?
Lordship may kindly see.
There is also problem.
Yes, my lord. Lordship may kindly see page 21 for the agreement, my lord. Because the alternative remedy is stipulated in this agreement only for the informant,
There is an
page
agreement.
21. That was notarized at Tifu, Karbi Anglong. Lordship might have got it.
It's loan.
Yes, my lord. Lordship, clause number 2, that I have borrowed an amount of rupees 15 lakhs only from Sri Golom Bogi, son of so and so, so and so.
Yes, Mr. Then what happened thereafter? Yes,
Lordship,
registered.
thereafter, my lord, lordship may again, I would like to
Investigated.
point out, my lord, yes, case was registered, my lord. But before that, my lord, lordship may kindly see one legal notice is there from the other side, from respondent number 2, my
Okay,
lord.
then what happened? Investigated case.
Yes,
Then
we participated, my lord. We took bail, my lord. Lordship may kindly see page number 36 for a moment, my lord. Page number 36.
what is that?
Lordship, it's a fact that we have taken some financial assistance from the informant, my lord, but we are repaying back it, my lord. This is reflected from the legal notice sent by them to us, my lord. Page 36, my lord. That you have taken in declaration that you will refund the total amount of rupees for 17 months with interest 4% per month for rupees 10,20,000 only. That is the principal amount of rupees 15 lakhs only as 4% interest, and the total refundable amount of rupees 25 lakhs along with the interest, my lord. Only accordingly that the balance amount will be refunded by you so and so only. Number 2, the balance amount will be refunded by you for rupees 16,85,000 on or before 31st
Yes,
of December
Mr. Lord.
positive.
Yes.
Yes, Lordship, here the applicant, Lordship, in the month of October, Lordship, 2023, now he stopped paying the amount, Lordship.
Oh, so you want,
That's why, Lordship.
you want police
That's
to,
why police authority has been
you want,
approached, my lord.
you want to use police. Okay, police is sincerely, I think, being used. Very difficult.
Yes.
In fact, lordship, I have annexed all the documents. The payments have been made through online mode, my lord. GPay or RTGS.
We'll call for the record then.
Yes, Lordship.
Yes, my lord.
Hard, Mr.
Take all it.
Okay, we call it. Land counsel for the petitioner. Also hard, Mr. Lloyd, Land PP for this team.
And Lordship, here, he added as,
Yes.
informer as Lordship, respondent number 2.
Yes, notice may be issued for
Notice
them.
that.
By filing this application under section 528 of the BMSS 2023, the petition applies for setting aside and passing of the FIR dated 23/5/2025. Log before which court?
Lordship,
of
Papu Hills Police Station, my lord.
Registered as Papu Hill Police Station case number
60/25.
stock 2025 under section 420 stock 406 of the Indian Penal Code. When this was lost?
My lord, 25, but
Why
but
this IPC?
this is on the basis of the agreement, my lord, entered at Difu, Karbi Anglong. This is another point, my lord.
So in Karbi Anglong,
It was not lost, it was lost here only.
there only. So since it is connected to the Karbi Anglong place, that is why it is IPC now,
Yes, my lord,
not BNS.
not BNS. my lord. Because agreement was dated 23, my lord, 25/23. The loan agreement was dated 25/23.
So should be BNS.
Yes, no, Lordship. It's a
25/23.
Lordship.
Register is when
Yes,
it was
at Difu, Karbi
registered?
Anglong, my lord. It was notarized and the transaction took place
Maybe, but
Before coming into the-
FIR was closed when?
on 23/5/25.
2025 only,
Yes.
then it is BNS. I think this also we need to obtain instruction, why BNS, why not? Yes, why not BNS? Why-
Since course of action arising in the year 2020.
Maybe, but then complaint laws now, FIR.
If I'm not wrong, my lord, lordship, section 530 of
One.
BNSS, my lord. Section 530 perhaps. my lord,
531.
531. That
Mixed reference, my
No,
lord.
pending cases,
Pending
it
cases.
it is already registered. They will proceed as per the IPC
Yes.
only, but then this, now that registered, it is registered
Yes,
now only,
Yes, yes,
it has to be BNS. Okay. Call for a scan, sorry, issue notice, call for a scan copy of that case diary, staff, since Mr. Lloyd Lanet PP appear and accept notice on behalf of the state respondent, no formal notice may be issued. However, the petitioner shall take steps upon the respondent number 2 by a registered post with AD as well as by legal process. Within 3 days from today, start. So where he stays?
my lord, I have the interim prayer, my lord.
Where do this is village? Police station from here, rather. Okay, list is matter. When can?
2 weeks, Lord, after break, Lordship.
Okay. Automatically it will go, I think, because there's a private respondent.
Yes,
Okay.
yes.
Okay. 22.
20.
This is matter on 24. Okay.
But till then, my lord, investigation may be stayed, my lord. Till then.
Lordship, he is already in the bail, Lordship.
We do not know. We do not know exactly, but then it appears you have a case, but then not now.
My lord, still I am being called for, my lord. I am being called by the IO, my lord. That is why.
Then you apply for the pre-arrest bail.
We have already applied and that has been granted, my lord.
But then why you are worried? What is the problem?
At least, my lord, till the return,
Let him
further
investigate.
investigation
Nothing
may
will
be stayed
come out.
because
Let them investigate. Nothing will found. Let the.
that is why, my lord. This is only because of money agreement, my lord. Money agreement, and we have been paying back. We are paying back.
Let us see. Let us. If it is money agreement,
Yes, well, that is the money
Yes.
agreement is referred to in the FIR, my lord.
yes, that will go. But then let us see. But then since it, we without going through the record, we will not.
Now,
straight away.
Lordship may kindly say, for a moment, my lord.
What is this? Okay.
Lordship, my lord, during the course of bail hearing, my lord, page number 49, my lordship may kindly see
Page
49. During the course of bail hearing, my lord, our bail hearing, page number 49, lordship may kindly see that on the other hand, the learned public prosecutor states fairly that
where?
page
Page?
49, my lord.
No. Okay.
The last
Hmm.
sentence, my
Hmm.
lord. On the other hand, the learned public prosecutor states fairly that the applicant has in fact paid part of the loan amount to the informant and that he should pay the remaining amount to the informant. That only because only amount regarding the payment of money, my lord.
What
And we are paying the amount, my lord. We are paying the amount, my lord. Even after getting bail also, we are paying the amount, my lord. That is reflected, my lord, in my petition, my lord. Nothing remains, my lord, for the sake of investigation, my lord. Till returnable date, my lord, at least, or the respondent number 2 appears, my lord.
No, Lordship, this amount was paid during the pendency of the bail application, Lordship.
No, my lord, before affair was lost, my lord. Before the affair was lost,
Investigation will not affect you.
my lord, before the affair was lost, payment was made.
Ultimately,
that is why the-
ultimately we will have to pass, but then at the moment, since investigation will not just interfere at the moment. Okay. Ultimately, it will go, since you are protected.
my lord.
Don't have to worry.
My lord, my apprehension is that investigation might culminate in something
That
else,
is why
my
you
lord.
clarify before the police. Give your statement. We'll see your statement also.
We have already
And
given
then,
statement.
then you say, we'll see.
Our statement has been
if we
recorded,
can-
my lord.
If we can direct the police also, if this is a clear case of a civil case, why he has to register? So you give your statement there. And then show the paper also, if you have any loan paper, anything, and repayment, etc. You give it,
Everything has been
and-
furnished, my lord. Everything
Yes.
has been furnished.
then let it come. We'll consider all,
Everything has been
and
furnished.
we'll consider all and pass necessary order. Clear case that it's a civil nature.
My lord.
Okay. Wait for some time. Okay.
Item number 7.
We'll ask the police to show where did he see the criminal in this case?
My lord, at least one observation may I pray for, my lord, that he may not be disturbed till next date, my lord, at least.
What,
Because
sir, you are already being protected. What are you saying?
My,
Okay.
May it please your lordship.
Yes.
Lordship, this is an application filed under section 528 of BNS, praying for quashing and setting aside of the FIR dated 09 September 2025.
Okay.
Lordship, here the complainant is the petitioner number 1 and the accused person is the petitioner number 2. The matter is pending before learned judicial magistrate first class. Okay. So, Lordship, the nature of the accusation is section 78 close to BNSS. It is an offense for committing of stalking, stalking, Lordship. Lordship, it is imprisonment is less than 3 years, with or without fine. It is bailable in nature and non-compoundable in nature. The second section is, Lordship, section 66E of IT Act 2000. Lordship, it is both compoundable and bailable in nature.
Compoundable. And
Yes.
the first one is 78 is non-compoundable.
Non-compoundable, but bailable in nature. And the second is both compoundable and bailable in nature.
Okay.
Lordship, on dated 9 September, the petitioner number 1 had filed one FIR before Nirjuli PS that the petitioner number 2 is stalking his daughter while coming back from the school to her rented house. Now, thereby, on the next date, the petitioner number 2 was arrested and it was produced before the learned magistrate. But however, the petition number 2 was enlarged on bail because the section which are levied is bailable in nature. Now, Lordship, on dated 18 September, both the parties have executed one deed of mutual agreement where the complainant number, petition number 1 had clearly stated that
He said 78 is non-bailable.
non-compoundable but bailable in nature, Lordship.
Bailable.
Yes.
And then the 66 also.
Yes, Lordship.
It is compoundable also.
Yes, Lordship.
But 78 is non-compoundable, although it is bailable.
Yes, Lordship.
Where is the FIR you said?
Lordship, this is in paragraph number 3, Lordship.
No, FIR. Where is the
FIR, yes,
complaint?
it is annexure number 1, page number 19, Lordship. Is the FR final?
Where is the content of FIR?
Yes, Lordship.
How it will help me to understand?
Okay,
What
Lordship,
is the
if
allegation?
my lord will come in page number 21. And there is an forwarding letter.
Where is the FIR? Content of the FIR.
Yes, Lordship. I could get this much only the material from the after applying the CTC. Here is the case, Lordship.
You don't know which one is a FIR or the complaint, the content. Unless we see the content, how would we understand?
Ship FIR is 20, Lordship, page 28.
See, the council
Yes, Lordship.
still doesn't understand
No, Lord.
what is to be annexed while praying for setting aside and quashing off.
Lordship, I do understand. I had filed the CTC, but I could get this much material only from the office of the.
Who prevent you from making another application? This is not the FIR, content of the FIR. Kindly give me the content of the.
Yes, Lordship.
You are entitled also.
My lord will come in page number 20 in paragraph 12. First information content.
Then you should have typed it out very small.
Yes, Lordship. In paragraph number 3.
Record need to be called.
Lordship, this is Lordship, this FIR is also already there, Lordship, and the statement, Lordship, on the page 21 also, the forwarding or Lordship, they have the gist of
See.
FIR is here, Lordship.
I'm looking for the one which was written by the informant. In the content progress investigation gist of FIR. See, gist of FIR. Okay.
Yes, gist of FIR is there.
Gist of FIR.
Yes,
Don't, please, don't depend on the gist of FIR.
They have Lordship.
When the court asks for the FIR, it has to be the FIR lodged by the complainant or the informant.
FIR is there, Lordship, but they have
Where?
not.
Where
in
is
the
the
page
FIR written by the informant?
19 and 20.
Where?
Lordship. 19, 20.
How it is written by the, how it is FIR written by the complaint lodged by the informant?
This is the FIR, Lordship, in the page 20, but they have not annexed that type copy, Lordship.
That is what I am saying.
Yes, Lordship.
Why are you trying to prove? Now my query is whether the record need to be called for here in this case.
Lordship, here this is settlement, Lordship.
Yes, Lordship.
Joint,
Yes, that is why I'm asking you.
Lordship. We can do, Lordship, we can,
You have objection?
Lordship, this, as per this joint settlement, Lordship, they have settled the Lordship, dispute, Lordship, in the, within 2-3 days, Lordship, because the FIR, Lordship, they have lodged on 9th, Lordship, 9th of, 9/9, Lordship, and the same month, Lordship, on 18th of September, they.
When FIR was lodged?
9 September.
9 September.
Where do we find that?
Page 19, Lordship.
Okay, this is still under investigation.
Yes, Lordship.
So
Yes, no.
you are praying for what?
Praying for
What
Lordship.
is your prayer?
Lordship, as both the parties have executed the agreement between them and
What is your prayer?
for quashing and setting aside of the proceeding of the
Now
FIR.
give me FIR. I'll set aside and class.
Lordship, there is in page number 20, para number 12.
I cannot direct.
Yes, Lordship.
Page number 20, para number 12 should be set aside. We have to annex FIR. Mr.
Assington.
Counsel for the petitioner. I think you need to, annex the FIR. If you want the FIR to be quashed, set aside and quashed. From here and there adjustment, page number so and so, that should be set aside and quashed. That's not possible. Will not adjust it in that way, okay? This is high court. When you are when you are praying for setting aside the FIR, you have to show the FIR. This is the FIR which you are praying for setting aside.
Yes, Lordship. But I had applied for the CTC. I could get dismissed only the material from the respective court.
You are advocate.
Sir.
You are advocate. Don't speak like a layman.
Yes, Lord.
Which one is a FIR? Which you know? Why should you submit that?
I'll file Lordship additional affidavit annexing the FIR.
Whether see, you have a case, but then because of your careless, it's very difficult. And we need to tell the council also, at least to do or to annex or make some a little bit of hard work, at least to give the minimum required documents. To produce the required documents before the court. At least court will be happy to see entire documents. Here is a case where you are praying for setting aside of the FIR. The FIR itself is not there. This is an application filed under section 5 to 8 of the BNSS. Praying for setting aside and quashing of the FIR dated 9/9/2025, registered as Nirjuli PS case number 81/2025 under section 78 within bracket 2 of BNS, read with section 66 within bracket capital E within bracket 2 of Information Technology Act 2000. Now you are saying pending before judicial magistrate first class. It is pending before judicial magistrate first class.
Lordship, the imprisonment is less than 3 years. It would
No, whatever may be. Is it pending before the judicial magistrate? That means charge sheet filed.
No, Lordship.
See, what is now?
If Lordship will come in page number 23, there is an order.
What order?
Yes, the bail order.
It's only bail order, Lordship.
Well, you will kindly read your prayer. Okay, just a minute. And what is to be set aside? Okay. Paying for setting aside and crossing. Very dictated. Crossing of the car, huh? Usually PS statement 81/2025 on a certain terms, huh? Okay. Code for the scan copy of the case diary. See, you said that it is pending before the, now you are trying to confuse the court also.
No,
And then call for the, it is only pending because investigation not yet completed. Call for the scan copy of the case diary. Issue notice since Ms. El Hage, then additional people appear and accept notice on behalf of the state respondents. The notice upon the notice upon the state respondents read staff, release this matter again on when?
Lordship.
Lordship, short date may be given.
So that house
Friday, Lordship.
Friday,
Yes, Lordship.
then on Friday.
All right.
Obliged. Item number 89.
May it please, Your Lordship.
Yes.
My lord, this case, these two cases can be disposed of by sending it back to the court below. My lord, I'll just take Your Lordship to the facts, basic facts. My lord, here the challenge is against an executive order passed by an executive magistrate, and in another item number 9 also against the order passed by the executive magistrate.
Executive magistrate.
Yes, one is in my favor, one is in their favor. But my lord, both the orders are illegal.
Okay.
My lord, I'll just take Your Lordship to.
One in your favor is also illegal.
This is also illegal.
Okay, admittedly.
And then one in there in
Their
the
favor also.
under favor is also illegal.
The case itself is illegal, definitely.
In fact, the matter has been remanded back to Supreme Court.
Remanded back by Supreme Court. Okay.
My lord, I'll just take your lordship to the annexers. I'll show how this is illegal
Okay.
and why it should be remanded back to the court below.
Okay.
Let us come to, my lord, page 1 onwards.
Of your petition.
I will not go into the marriage facts. I'll just make a basic descriptions, my lord.
One of your petition.
Yes,
This is
CIP number 20.
20. Okay.
My lord, from page 16, my lord, there was a dispute regarding ownership of a query. My lord,
Okay.
we have filed a complaint before the deputy commissioner.
Hmm.
And my lord, page number 17, also same thing
This is complaint lodged
by the petitioner in
okay.
item number 8, my lord.
Okay.
So likewise, in exercise 17 also, we have filed to the additional deputy commissioner.
No,
And
this
the-
is annexure 1 is filed by you
Yes,
before the deputy commissioner.
deputy commissioner.
Against,
And 2 also before the
no, this is
ADC.
against
Uh,
respondent.
respondent.
Okay.
This is regarding ownership about query, my lord.
Okay.
So this is not basically not as per the format. But then, my lord, this case was endorsed to the KEBA.
Okay. Where do we find that endorsement?
Yes,
order?
page 18.
Case was endorsed.
Yes.
Okay.
Then at annexure 4,
Okay.
page,
You are arguing the matter for disposal.
yeah, I'm just taking your lordship
Okay.
on the basic facts so that this can be disposed of for remanding back to the lower
Okay,
court,
okay.
court below, my lord.
Okay.
My lord, page,
So this is endorsement by deputy commissioner.
yes,
No. This
or
is
no, on behalf of the office by the DLRSO. This is also DLRSO also is not supposed to do this, but then
No,
this is,
well, whether in the complaint lodged by you, where is the endorsement?
there is nothing, my lord. It was verbally the directed for initially most probably the deputy commissioner must have thought that this is a land matters. So let the DLRSO look into it. But then later on they realized that it cannot be decided by the DLRSO. So it was sent to the KEBA,
Where is the
page 18.
order of sending?
18.
18 is sending to KEBA.
Yes. This is
No,
to,
DLRS, where you said that DLRS, so where is that? Page 18 is,
page 18 annexure 3, my lord.
okay. But you refer to the DLRS, so where is that?
This page 18 is by the DLRSO,
Okay, not by DC.
not by the DC. So this is,
DLRSO,
yes.
is it, how he is connected with the?
My lord, as I've submitted, the DC initially thought that since this is a land matter,
Okay,
let him tackle this.
Okay.
But then DLRSO, on instruction later on, he reported to the DC that this is a dispute between the ownership, so I cannot take it up. So it was DC directed or verbally directed the DLRSO to forward it to the KEBA.
whether he referred that it was on the direction of deputy commissioner? Because he cannot.
Uh, So, this is
He doesn't have a power.
yes, it may be irregular, but not illegal as per se, my lord.
Okay.
So anyway, my lord, the KEBA was held in Annexure 4, my lord. The English translation is at page 20.
Okay. And it was decided,
Yes, my lord. I'll just come to paragraph 2.
yes.
Sir, CG Igone query was taken out from BWC, LBNC, and thereafter Bali Taipodia has dated 9/4/2019 up to 2020, sold it to Sri Tadu Taipodia. After that, from November 2020 to May 2021 was sold to Sri Gokar Taipodia, basing on all the premises. The Keba passed that, well, this is the decision. It was late Ego Taipodia's traditional fishing has been declared. Ego Taipodia's,
It was late Ego Taipodia.
yes. Now Ego Taipodia is the grandfather of the petitioner here in CRP number 20. So it recognizes the ownership by late Ego Taipodia. It declared the title
By this order?
by this Keba decision. And then second part is,
No, just a minute. Here, where is your name here?
my name is not there, my grandfather's name is here. Ego Taipodia is my grandfather.
Ego Taipodia is your
Yes.
grandfather. Just a minute. Then this need
Ego Taipodia had two sons, Gokar and Godu. And Gokar, Karmu and Carlo. Karmu is the second petitioner here. And from Godu, Duga, Dui, and Dumo. And his eldest brother, Duga, is the petitioner number 2. So it is their,
Where have you stated this, that they are the descendant of this? Ego
well, not,
Taipodia?
this has not been stated here, but then
Oh, then it will be.
But then it is a fact that it was declared in favor of Ego Taipura. Now, the second part. Now, I will come back to why we have filed an appeal also. Then, Malad, again come to page 20, Malad.
Yes.
Then second
in
part.
page 20.
That after the declared, as the owner of traditional fishing area may be allowed to operate free of cost for 2 years from 1 May 2023 to 30 May 2025. Also, rupees 20,000 may be given in addition to it. Thereafter, Igone quarry will remain in the name of Bali Taipodia. So, after having declared the ownership, then
Now see, the petitioner's name is not in the Keba decision.
yes.
It will be difficult to make out.
No.
Unless
Yes,
you have stated in
you know,
petition
that is why.
later on.
Now that is why against this second part of paragraph 20, the ending part, we have filed a appeal at page 21, my lord. This is an order decision that at 12/3/2021. Then on 17/3/2021, we have filed an appeal before the deputy commissioner. And my lord, at this stage,
You are agree. You are
agree by the
agree
second part
by-
of this decision.
the Keba decision.
Keba decision, the second part of paragraph 2.
So Keba decision is against you and in favor of the respondent.
Not exactly,
Okay.
but then in this paragraph 2, there are two parts. One is it recognizes, declared the title of this query in favor of the grandfather. So as per this law of inheritance, his son, Gokar and Godu, and his offsprings, they are now the owner of this query. Now, the second part, this second part, it says, as the owner of traditional fishing area may be allowed to operate. We are the present people in the area. We have been allowed to operate free of cost for 2 years. That is May 2023 to May 2025. And also rupees 20,000 may be given in addition to it. Thereafter, that means from May 2025, the ownership will be not with us, but it will go to the Bali Taipodia.
Who is Bali Taipodia?
Bali Taipodia is the name of the area the whoever or any Typodia resides in Bali village will be the owner. So, my lord, here, if we argue this case, my lord, whether any authority can declare it as a community lane or not, that issues will come. But then, my lord, what my submission is, we have filed this appeal on 17/3/2021. After 4 days only. This is within the time limit, and this is as per the 1945 regulations. During that time, the Arunachal Pradesh Civil Courts Act 2021 wasn't invoked. It came into effect only on 12 April 2021.
Yes, yes.
So therefore, this is totally in terms of legal provisions. Now thereafter, my lord, we have raised this issue. I am not going into the facts. See, this case was, when it was pending, the executive magistrate, under the provisions of 46(1) of Assam Frontier 1945 regulation, my lord, at page 23. Page 23. Page 23 and 24, he passed an order in my favor. But here, since we are the officials of the court, well, this section 46(1), 1945 regulation.
Yes.
Under this under this section 46(1), the executive magistrate could not have passed this order, could not have taken up this proceeding at all, my lord.
Okay.
Because first thing is, appeal is pending.
Where he has mentioned that he is passing order.
Yes,
under the same.
on top, my lord, just below this, in the code of executive magistrate, case number 5 of 2021,
Yes.
under section 46(1).
Yes. So this order was passed in whose favor?
In my favor.
In your favor?
Yes.
You are? Who is Senim Typodia? You are?
We are grandson of Igo Typodia.
Igo Typodia.
Yes. My lord,
You are Duge
yes, Duge Typodia.
and Karmi.
Yes. Now, my lord, my resolution submission is, let us not go into the facts or merits of this, all this. Only let us go by the procedural lapses.
Okay.
So, appeal is pending. The executive magistrate passed this order under 46 in my favor, but this is an illegal order. My lord, at page 25, 25, suddenly the deputy commissioner again issue an order for almost like review types by the executive magistrate again, another executive magistrate.
Review of the same order.
Review of the Keba decision. I mean, whatever the decisions, we have raised our objections.
No, by this judgment, what the deputy commissioner or executive magistrate has said about the Keba decision? Referred, whether Keba decision is referred by this judgment in order?
Yes.
What it says about the Keba decision? Affirmed?
Yeah, affirmed.
Okay.
Affirmed, and
So-
it went in my favor.
Okay.
That
Keba
is
also
the,
decided in your favor?
yes, grandson of Keba also decided in my favor, the first
Okay.
part.
Okay.
For the second part, we have filed an appeal. In this order also, it went in my favor.
Okay.
But, my lord, this is
illegal.
illegal.
Okay.
Then thereafter, at page 25 onwards, my lord, another notice, my lord, here on, my lord, 25, page 25.
Yes, yes.
Whereas on receipt of an application received from Sri Sendo Typodia, son of Jumsen Typodia of the Bali village in connections with the land dispute case located at CG River, in between Sri Durga Taipodia, Karmu Taipodia, Bis, Sendo Taipodia, so on of such and such, are hereby directed report undersigned for inquiry into the dispute. Therefore, such and such. My lord, again, this case was taken up. This is the 29 July 2021.
Yes.
So most probably the complaint, if any, must have been filed in and around or before, just before 29 July 2021. First thing is, this case was decided on 12/3/2021. Appeal period is 1 month, and this is beyond the time, and there is no condonation petition, no condonation. And after this, my lord, we have filed our objections. And now, my lord, at page 13,
Who is this Sendo Taipodia?
he is a third party. He was never a party in the Kaba decision, initial Kaba decisions.
Okay.
This is also one of the grounds why it is not sustainable. Anyway, my lord, at page 38, my lord.
Thirty-eight.
38.
Yes.
So, my lord, this went against me. This is the 22 September 2021.
Yeah.
This has gone against me, but my respectful submission is these proceedings also could not have been taken up. This is also an executive magistrate. The value of the property, pecuniary jurisdiction of assistant commissioner is only 500. And here the Kabang itself talks about
It
the
was
ownership and then
increased
paying.
to 5,000.
Yes.
Okay.
So, my lord, my respectful submission is both this order that at 15/5/2021 at page 23 and order that at 22/9/2021 at page 38 are illegal, and the appeal which I have filed before the deputy commissioner at page 21 annexure 5, my lord, it stands revived. Well, my resolution submission is let all these cases be remanded back to the deputy commissioner, who shall take up this matter as per law. Now, my lord, at that time, during those time, deputy commissioner had the power to take up appeal matters, but now he has no power. If it is ordered that it should be the deputy commissioner should proceed as per law, then it will be transferred to the civil judge at Pasigat. Now, my lord,
Now, if the deputy commissioner doesn't have the power any longer, then why not straight away to?
no, my lord, because this is addressed to him, and your lordship will pass an order in such a manner that he will pass further order as per law. As per law, the present as per provisions of law is that he will have to transfer it to the proper civil judge, civil court. And if any objections, whatever it is, let them file before the deputy commissioner, before the court below, because there will be a disputed question of facts. So that court below is the proper court who will determine all those issues. Lord, I suppose the advocate other side also will be agreeing to this. Simply, my lord, without going into any facts or merits of this case, only on procedural matter, all these disputes regarding the factual aspect, claims, or whatever it is, we will take it up in the proper forum.
So direction to the deputy commissioner, who in turn will forward it and forward it to the proper court
Yes,
as per the
as per law.
as per the. Okay. So this in one item. Number 8.
9, my lord, come on, let the
9, you okay, you have. Okay. So just a minute.
let a common order be passed.
Then ask Mr. P. Patil, Land Council for the petitioner in CRP 2021, huh? And Mr. K. Saxena for the, who else, the respondent? Well, the state is also.
Yes, sir. I'm for 1 and 2, Your Lordship.
Only item number 8.
Item number 8, Your Lordship.
Okay, and Ms. Pang, then a government advocate for the state respondent number 1 and 2 in item 8. Huh? And 3 is Major typo there.
My lord,
Okay, and Mr. Kamal Saxena for respondent number 3, staff. And respondent number 3 and petitioner. Okay. And for the petitioner in item 9, huh? And Mr. Partin, respondent in item 9. Okay. And in item 9 also the state is.
No, no, Your Lordship. Only in item number 8.
Okay, okay. I'll see. So, if there is any confusion regarding the parties, name of the parties who involved, probably I may have to list it again one day, just for confirmation or to clarification. Let me see. Okay.
Order may be reserved.
Order will be reserved.
Yes.
Okay, because now the party, there is a confusion, otherwise.
Well, In item number 9, I am for the respondent number 1 and 2 only.
Yes, yes. 1 and 2, how many respondents are there?
4 respondents.
4, and who?
Nobody is representing them.
Okay. In item number 9, Mr. T. Partin for respondent number 1 and 2, and none appears on behalf of the respondent number 3 and 4. Okay. So, hearing concluded, the concluded judgment reserved. So, if only with regard to the party, if there is any confusion, I'll get it listed once.
The appeal is at page 21.
Otherwise, the concept is clear. Okay.
That's the
Obliged.
Just a minute.
Item number 10 and 11.
Yes.
My lord, so far this appeal is concerned, the appeal is already admitted. The appeal is already admitted.
Okay.
The course has been called for. Now the matter is for final disposal.
This is for hearing.
Yes, my lord, final hearing.
Already admitted, then it has to go to for hearing.
Yes, my lord.
Okay. So the direct for listing it for hearing.
In fact, my lord would see that previously also there were
It
orders
was
that it
already
is to be
admitted
taken up
by
for
whom?
back-to-back hearing.
Hmm?
It was to be taken up as per order of 7/5/2025.
Okay.
It was to be taken up for hearing on a regular day-to-day basis. Because in this matter, my lord,
इसको संतोष इसको ये available है.
the execution is also pending, and now 6 months have also gone by. There's no express stay, but then provided that the hearing.
The records, affidavit notice filed by the land council for the appellant. What affidavit was to be filed as per the office order?
That we
Office note, affidavit notice filed by.
we had filed an affidavit
Readings are
yesterday.
completed, my lord.
Yes.
Office
Readings are
note says.
completed so far, my lord, other matters are concerned.
Hmm?
My lord, this is an appeal, my lord.
Okay.
So there is no question of any filing any affidavit and all that.
Why it has?
No, in the IA, my lord, and there's an IA for stay. In that IA, we have filed an affidavit. my lord.
Okay.
Oh, that was,
Not in the appeal,
that was
not in
to
the
be-
main appeal.
that was to be filed, my lord, last order, my lord, before the executing court. If your lordship kindly take the last order, my lord.
Is this IA?
No, this is main, my lord. LA appeal 2 of 2024.
Okay, this is LA appeal only.
Yes.
Not in LA appeal only is office note. Affidavit not yet filed.
No, my lord, lordship will, may I just
Ah.
point out to my lord, probably the office has misunderstood the thing, my lord. If your lordship kindly take the order dated 20th of August, 20, my lord, 20th of August.
Yes.
My lord, I'll take to next page. In the meantime, in the execution case pending before the district judge, Alo, West Siang district, an affidavit shall be filed by the appellant on or before ISNA, bringing on record the order that has been passed by this court. Or this court passed an order But what happened, my lord, they have filed a, my lord, execution case
Okay.
on, my lord, in April 2025, my lord.
Mhm.
Now, my lord, after that, the matter was taken up by this honorable court, and on 7/5, an order was passed by this honorable court.
Hmm.
If your lordship kindly come to that. No, no, मेहनत है, मेहनत है, 7/5,
Order to report.
main,
Appellate pass करेছে.
Yes.
Lord, I'm not taking my note, the next page. The connected LA appeal resolves surrounds the dispute as to whether the land acquisition in question shall covered by the Act 1894. Now, that is the basic core question, my lord.
Hmm.
1894 or the Act 2013. It is also on record that compensation determined in terms of the Act 1894 has already been paid to the affected person. We have already cleared, my lord, whatever that was. However, execution proceeding is pending for execution of subsequent award by reference court in terms of the Act 2013. Accordingly, Mr. Agarwal, the senior counsel for the appellant, has insisted on the stay of the execution proceeding in question. On the other hand, Mr. Pathak, Leonard counsel for the opposite party, in his usual fairness, submits that since the appeal is pending, they will not pursue the execution proceeding as of now. However, matter should be heard at the earliest, and the appellant should not delay the matter by taking unnecessary adjournment. In view of the opposite consensus, this the matter on ITNA, and if necessary, it may be taken up on day-to-day basis. Therefore, last order is important, last part. Taking note of the submission of Mr. Pathak, Leonard counsel, that they will not pursue the execution, this court has restrained itself from passing any interim order. Because in fact, on that day, this honorable court was to pass an interim order, but since they say that no, don't pass any interim order, we will not pursue the matter. And accordingly, the matter is proceeding, and their consent, their whatever undertaking they have given, that has been repeated in other orders followed by that.
So there was also process for settling the matter out of court. What happened to
My
that?
lord, we had represented,
failed.
my lord,
My lord.
they could not probably take further instructions on that.
Settling the matter out of court?
That settlement is without order.
Oh, that is so, my lord, we have already informed our party.
Hmm.
But I don't think there is anything.
Failed.
So, settlement, my lord, they have given a representation. We have already written to our client that if possible, kindly consider and pass the necessary order. But I don't think that they have. Lord, ultimately, my lord, the amount is so huge. The chances are, well, it has to be sent to ministry and all that. I don't think that it will be anyway, my lord, it will be done. Around more than 300-400 crores, my lord, additional compensation has been granted by the, my lord.
These are the projects, my lord, inaugurated by the Prime Minister yesterday, my lord.
Oh.
Hydro project.
Tato 2.
Tato 2.
So I think it appears that it will take some time. Hearing.
No, it will
So
take
what do we do?
Take time. My lord. It
So
will not be
here-
possible to finish it, my lord, in
Not possible. So we'll fix for hearing that
my lord, after vacation,
after vacation, any date,
24th, my lord, is a date available, my lord, on
24.
Just till 21st, I think. Court is closed.
Mr.
In fact,
Yeah,
till
Agarwal.
21st, Guwahati
Planet
is closed.
Senior
21st is also Diwali.
24, 25.
Assisted by
24.
Mr. Okay, Mr. Napatu, Planet Council for the appellant. Also had Mr. B. Pathak, Planet Council for the respondent number 1 to 71.
1 to 71.
Okay, and Mr.
One
Yes,
state-
Mo, you are also? Mo, you are for?
11. That matter will come.
Okay.
But then I am also connected in a way because the issue
11 is
raised-
also connected.
it's
What
connected in a
happened,
way
my
that
lord?
the issues
What
are
happened, my lord?
somehow they are connected.
Basically, my lord, both the issues are, my lord, same.
Okay. The pleadings are complete. As requested by the Lana Council of Other Parties, let this matter be listed on
Hearing for on
for
24th,
hearing on
24th of October.
24/10/2025.
Well, in the meantime, whatever they have not given the my lord, that should come.
My lord, and that I have some difficulty, my lord, because I had given that consent. That consensus I had given, my lord, that it was to be taken up in the month of May on a back-to-back
Till next
basis.
date, till next date, because you have on that day on your, of course,
Yes,
submission.
of course, my lord. But then my
So this-
difficulty is that, my lord, execution is already pending. And within 6 months, the executing court also now has to, as per the Apex Court guidelines, have to submit a report.
No,
There's
that
no
guideline
express
will-
stay. There's no
That
express
guideline will not
stay.
apply because, my friend has given a, undertaking that he will not pursue the matter. So, of 6 months
No.
period, as far as the Supreme Court has given a direction. In my humble submission, that does not apply.
No, that undertaking was because,
And
my
my lord,
lord,
it is not
we
a
were
case.
to take
My
up the
lord,
matter for
possible
final
can you
hearing in
consider
June, my
those
lord. Now it
cases?
is October.
In those, I have not taken a time, my lord, if your lord.
I understand, of course,
I
of
have
course.
not
It has
taken-
somehow not happened, my lord. Somehow it has not happened.
It has not happened. Even today I am ready, my lord.
Today, I understand it is constraint of time, my lord.
Till the next date is undertaken by the land council for the petitioner. The execution proceeding shall the remain state is per the order dated 7/5/2025. Okay.
My lord. My lord, on the next date, if my lord, if required, my lord, that IA for stay should be independently taken up, my lord.
It's still definite.
That IA 252, my lord.
Insist on that.
My lord. If some order, judicial order is passed thereon, rather than putting it on my
No,
consensus, my
hearing-
lord, whatever be it,
Final hearing on that day. Let us try
my lord.
final hearing to dispose of the entire matter because I've seen the order because it has to be, the direction is there that to hear it on day basis. But that could not be done for.
Yes.
So on that day, let us try to dispose of.
Because this next item also had got tagged together, my lord, and
Okay.
that was taken up.
Okay, in next item also, Mr. Sunil Maulana, Council Petition is present. Who is here?
May I plead your lordship? I think item number 11, no doubt rising out of the same award. But their case is that already the case is decided by reference authority. But in our case is when we file a reference before reference authority, it was dismissed on the two grounds. One was a delay.
These matter similar or otherwise
No,
it will be hard together.
no, it has to be heard separately.
Then-
So I will pray that
It
it may be
is
taken.
with item 10.
No, it should be heard. It should be segregated and it should be heard separately, Your Lordship.
You want this matter to be segregated?
Yes.
May I just?
Yes.
Lord, here, what happened, my lord, that they are also, my lord, from arising out of the same, my lord, acquisition proceeding. They were the party before the reference court. But, my lord, they said that no, our power of attorney has been taken by fraud and all that, my lord. So they said that we will withdraw from that reference. And later on, my lord, they filed a subsequent reference to before the, my lord, district judge. Now, my lord, no, not district.
Here also the pleading complete.
Pleading is complete.
Listed for hearing.
Yes.
Okay. Then record the.
So it may be not with this item number 10. It should be heard separately. It has to be segregated.
No, question will be the same because your honor, your lordship will kindly see.
No problem, because no problem. Let it be listed because on the same day, in any case, they are coming on the same day. So it will be listed, but then hearing will be done separately.
Yes.
And order also, judgment, any order passed will also be separate.
Yes. So it should not. It should not be with take with the 10.
It will come along with, but then it will not. It is not being tagged. I think the orders. Where is the? I think 11.
Because
Yes, it's
because in our
Right.
prayer we are challenging only the dismissing order passed by the reference authority. So only our prayer is that this matter should be sent back to the reference authority and reference authority can decide fresh on merit because reference authority had dismissed only on two ground. One is the section 65, that is the work of a deputy commissioner. Deputy commissioner has not sent the detailed comments, that is one. Another is that delay. So in the case of delay, the reference authority has no power to decide on delay. Basically, it is the deputy commissioner or collector has to decide on the delay. So delay in our case is we filed together with the earlier item number 10, but then we withdraw from that reference saying that we want to separate file separately, and accordingly we file after 2 months we file the same reference authority, but then concerned reference authority is that dismissed on the ground that you have this, there is a delay, you have not control of
Okay,
delay.
okay.
Whereas the deputy commissioner has the authority to decide the delay. The deputy commissioner has has allowed, and then before the reference authority, and reference authority has the power to, I mean, reference authority has to decide on merit. That was the, in our case. This is our case. Your Lordship.
And it appears that others also, the separate
Your
order has
Lordship
been passed.
admitted the-
Okay, and also her, Mr. P. Agarwal, Lion Senior Counsel for the respondent, Now, you are for respondent number 2,
No, I am for respondent.
respondent.
They are for the petition.
How many respondent?
12 and 13.
Yeah.
Lordship, in this case, as per the last order, we have filed a affidavit. Lordship, as per order dated 25/8/2025. This honorable court has directed the petitioner to deposit ₹70 lakh and to file the affidavit in this regard.
Okay.
So, Lordship, accordingly,
Hard, Mr. Taba, Lion Counsel for the petitioner, staff,
May I please, my lord?
You are for?
And for the respondent.
Okay, yeah,
My lord,
receive. The respondent has received 70 lakh.
we have received 70 lakh.
Okay.
But then, my lord, the rest of the amount, they have been directed to file the affidavits stating that what are their means to pay the rest of the amount. And how long will they be able to pay it? But madam,
Whether in the affidavit, in your affidavit, have you stated that rest of the amount will be paid on such and such period? Have you stated?
a specified time.
Yes. And I think you have to pay. What was the direction earlier to, with regards to the other amount, apart from this 170?
Lordship, there is no direction as of.
They were asked to state the means for payment of the
By which order? By which order?
order dated 28/5/2025.
When are you, 28?
25 August 2025. They were directed to state how are they going to make the payment, rest of the payment.
Okay. You file affidavit,
Yes,
another affidavit?
I have
Okay.
filed affidavit in my para 5 of my affidavit.
This affidavit was filed in compliance of which order?
25A.
Okay,
But my lord, they have not stated, the
Okay.
petitioner has not stated the.
okay, also, hard, Mr. After, okay, also hard. Miss
M. Karbak.
M.
M. Karbak.
Karbak, Lion Counsel, for the how many respondents are there? You're only respondent? Ms. Karbak?
Two respond, we are representing both the respondents.
Okay, Lion Counsel, hearing on behalf of the respondents, stop. Mr. Tava, Lion Counsel for the petitioner. No, Mr. Tava, One not Karbak. Just para. In compliance of the order and direction dated 25/8/2025. The petitioner has filed. The petitioner has deposited an amount of rupees 70 lakhs. Before,
In the loan account, Lordship.
in the loan account of, which paragraph you have stated?
Lordship, page number 150. I have enclosed the bank statement.
Okay, now, where have you stated that you have deposited this amount?
Page number, para 4 of my affidavit.
Okay. Deposited
Para
sum of rupees 70 lakhs only against his loan account number 190000069950 maintained in Arunachal Pradesh State Cooperative Apex Bank on 19/9/2025.
Yes.
Okay, and file affidavit to that effect by annexing the, what do we call this annex?
This is,
Chalan, what do we call?
this is deposit slip for.
Deposit slip. Okay. Stop the para. Ms. Kaba, Planning Council appearing on behalf of the respondent, acknowledge the receipt of the deposit made by the petitioner towards the loan repayment. However, she submitted is directed by this court on 25/8/2025. The way, which paragraph it was directed?
Lordship, case number 151 of my appeal.
The paragraph?
151, in the third last paragraph from bottom.
No.
The prayer for 4 weeks time for deposit the remaining amount of rupees 70 lakhs on the gift.
In the affidavit, I will say that affidavit in the file affidavit to that effect in proof of his payment of the aforesaid amount. Then come back to Karwa. Where it was directed that he should give a statement that what is the means for repayment of other rest of the loan.
Not recorded. It
Not
is
recorded.
Recorded, but it was, done.
My submission is
And Mr. Taba, before Karwa, Taba, Father submits that the rest of the amount where will be deposited where, how much time it will take? 3 months.
The amount is very high. Total amount cannot be able to deposit in one go. The toxic maybe took some time. Next, within 6 weeks, I will report.
No,
Because toxic,
there are more than 12 crores remaining amount, my lord.
toxic, there is
It's
a,
been more than, pending for more than 6 years. We are willing to concede to a specified period where
The
we can make it.
and praise for some more time. Praise for granting some more time to deposit the rest of the amount. Staff. The petitioner is granted to show your bona fide, you deposit whatever amount you say within in 6 months you deposit at least 2 crore.
At least half of the loan amount.
Okay. Granted 6 weeks time to deposit half of the remaining amount. You deposit. You deposit whatever is possible on your part. See, court cannot always manage for,
My lord,
and then for them also. See, property, I think is pending since how many years? You say that mortgage property probably will not fetch you more money. The remaining amount is 15 crore. Will it cost 15 crore? I don't think. It's with the building also. A plot of land 15 crore. Is there any plot costing 15 crore in Arunachal? Only land. To deposit at least 1/3 of the remaining amount. Okay. Please this matter after 6 weeks. Okay.
Matter number 14.
Yes.
My lord, there's
Yes.
paucity of time. I don't think I'll be able to complete in 30 minutes,
No,
my lord.
No, so only the question,
Yes.
because charge framed, you are
Yes.
challenging the order
Yeah.
by which charge was framed against you.
Yes, my lord.
See, the Lanat Trial Court has
Yes.
framed charge against you on finding that
Yes.
there is a prima facie case against you.
Yes. Yes.
So at this stage, can we go into the depth or the detail of the case?
No, we cannot.
Whether this court.
Yes, my lord. I quite follow, my lord. We cannot go into the details of the case
Hmm.
now, but we can go to that limited extent to see whether, while framing the charge or rejecting my discharge application, whether the court was right in saying that there was a prima facie case against me. To my humble submission, my lord, what did the learned special judge say was that she mentioned of a community collectively causing a rally, but rally, that's not a very important point, collectively damaging the government's property, my lord. Now, whether any overt act is attributable to me or not, that finding was not even there, my lord.
Now see,
Yes.
at this stage,
Yes, my lord.
say for example, a move
Yes. Yes.
leading around maybe
Yes.
500, 600.
Yes. Yes.
But then few of them,
Yes.
if the investigating agency
Yes.
or the informant
Yes.
identified,
Yes.
they will target that. And
Correct.
They have,
That's the point.
yes. There in this
Yes.
case also, how many of you are there?
My lord,
Totally, maybe more, but then here, charge frame against how many of?
16, my lord,
my
16.
lord, no,
16.
no,
Yes.
my lord, there are
16
20,
person
no,
whom-
my lord,
Hmm.
there are more than 25 accused were framed.
Hmm.
I am representing only the 16 villagers, my lord.
Hmm.
I'm not representing the student leaders, whoever led the rally, whoever were accused of, whoever were identified. For them, I say that yes, prima facie case is there, let the trial begin.
Mhm.
But I'm representing the people who have never been identified, my lord. Video recordings are there, nobody has identified. The complainant has not identified, the prosecution witness, 30 of them have not even identified. So that is the case, my lord. That's why.
Is it so?
My
It
lord.
was only after being identified only.
No, my lord.
May I, my
No,
lord?
no identification.
My lord,
Yes.
Even test identification parade was not even conducted, my lord. TIP was not even conducted.
my
I
lord,
will show why
No,
we
see-
were.
See, this
Yes,
entire, this, because this dispute of the fact,
Yes.
this court sitting in the, this is criminal revision.
Yes,
It is not even appeal,
It's not an appeal. It's
not
a
an appeal.
revision,
So in
my
the
lord.
criminal revision,
Yes.
this
Yes.
court may not
Yes.
delve into such a depth.
Exactly, my lord.
So,
My lord. My
and
lord.
what I found is that, where is the impugn order?
My lord, the
Page-
impugned. The impugned order is at page 224, my lord.
Hmm?
Page 224, my lord. If, my lord, at all there was some identifications, my lord, I have no case. This was shown to the special judge
He
also.
has appreciated, she has discussed the entire and
Yes. Can you look, how did she discuss, my lord? But before that, my lord will have to appreciate what was argued on behalf of the SIT, my lord, and what was argued before her by the defense counsel, my lord, and what was her observation. This much, my lord, can see.
shows that there are sufficient prima facie case against the accused persons and framing so and so. And then the the statement recorded under 161 CRPC is inadmissible. Okay, the total recorded drafts and reference, and they have examined by the prosecutor. However, in none of the prosecution witnesses.
My lord, can you look at this page 230? That is the observation of the learned SIT, my lord. Before, just to cut short.
Yes, after hearing.
After hearing, my lord. After hearing all the learned counsel, this court perused the case report
Yes.
and found that the Yobin community of Vijayanagar Circle as a whole were pressurizing the government to meet the demand of immediate deportation of Assam Rifle settlers from Vijayanagar Circle, and they even gave ultimatums. Just hold a second here, my lord. It is a student organization who are giving ultimatums. Yobin community, my lord, the apex body is the Yobin Welfare Society. Yobin Welfare Society was not giving ultimatum. It is an issue of the students, my lord. Now, my lord, however, on finding no favorable initiative from the state government, Mwajusa called for a meeting of the Yobin community members at Gandhigram on 10th December, and it was decided that they will act on their own way so as to pressurize the government. Every participant was asked to carry daws, rods, lathis, etc. with them. Accordingly, the mob, when armed with daws, lathis, etc. in unison with AYSU team in Vijayanagar on 11/12/2020, and on reaching Vijayanagar, buildings were damaged or burned down. Hence, as per the investigation, it is established that there was a conspiracy on the part of the accused person for committing the crime. And all the accused persons were well versed with the situation. They had the full knowledge, and there will be a violence and had voluntarily participated in the rally armed with daws and lathis. They had disobeyed the lawful order of the public servants, used criminal force on the police and administrative personnel who were to set out of the situation. They had also written a verbal representation each and brought hatred, contempt, to bring hatred, contempt against the state government as well as Assam Rifle settlers of Vijayanagar, thus affecting the maintenance of peace and harmony of Arunachal Pradesh and the country as a whole. This court has also perused the statement of witnesses where the name of some of the accused have been vividly mentioned having destroyed the government properties, my lord. Now the special judge says that on the statement, she has found some names, my lord. Whether my name was mentioned, if my name is mentioned, then I have nothing to say, my lord.
Just a minute. Anywhere the name of these petitioners have been mentioned by any of the witnesses
My lord,
in 161 statement?
my lord, this is the case, my lord, where the accused person, my lord, the petitioner, they have already admitted, my lord.
Where?
Their statement is here, my lord. They took part in the rally.
No, their statement before the police?
Yes, my lord.
161.
161 statement, my lord. And for my lord, framing of charges, my lord.
Whether any other person, other than the accused themselves, any other person has stated that they have seen this accused person?
There are no such statement, but but my lord, that statement,
police statement, it's a police statement,
161.
the person.
Police statement, though may not, that may be taken as evidence.
Police statement is, somebody has stated that, yes, I have seen Mr. A. Understand? Then, of course, justified.
But to my humble understanding, my lord, for framing of charges, my lord, for framing of charges.
Now I'm asking you,
Yes.
police statement, supposing if I state, if Mr. A state, I have seen Mr. B, okay. But then Mr. B himself and stating in a police statement that I took part. No one stated, no one have seen, none of the witnesses have stated that Mr. B took part. Then how do we believe? Because the police statement is not signed one, it's his own statement. On the basis of that, can you go ahead? How do you prove? Who will prove? Because he is not going to become a witness, the accused himself. Then who will prove?
My lord, that is, to my humble understanding, my lord, that is a matter of trial only, my lord. Because, my lord, for framing of charges.
Just I'm asking you.
Yes.
Simple question before. That because if no one has seen, none of the witnesses have seen or stated or took name of the Mr. X accused, only X. X will be standing on the dock.
My lord,
Accused. He cannot give his own witness.
my lord.
And who will prove against him now if there is no any statement?
Now, my lord, in the trial before this one, my lord, special court is going on, my lord. The PW stage is going on, my lord. So, my lord,
What is going on?
PW's, my lord. Prosecution witness, my lord.
Witnesses.
Yes, my lord.
How many have been examined by now?
By now, my lord, in the record is not clear, my lord. Latest record is not in the, my lord, TCR, my lord. By now, my lord, PWs are going on, my lord. Now, my lord, if I may,
think you have gone through
yes,
the
my
record.
lord. Yes, my lord. But the latest order is not annexed here, my lord. But if I may submit, my lord, for the framing of charges, my lord, for the framing of charges, only prima facie is.
That is what I'm saying.
Yes, my lord.
If there is no one has stated anything against any person, the accused person, where is the question of prima facie case?
My lord, 161 statement, my lord, the accused.
That is why I'm asking, who has stated against the accused person in 161?
The accused themselves, my lord. Accused themselves.
Accused will be standing on the dock.
Yes, that I can understand,
Who?
my lord.
Then
My lord, on the basis of their.
it is not 164 statement.
Not
huh?
164
Accused.
statement.
It is 161 only.
161. But, my lord, for conviction, my lord, of course, my lord, trial is required. For conviction, we can see the probative value of the evidence, my lord. But for the framing of charges, my lord, only the substantial material has to be seen, my
You
lord.
have to show at least one person is taking his name in order to show that there is a
My lord,
prima facie.
there is, my lord, videographic footage is there, my lord.
See, tomorrow, if no one has stated, no one has seen him participating, and tomorrow there no one will be there as a witness who will state, who will give statement that I have seen him, then in that case, why should we, you see, why should we punish the person?
My lord, there is, my lord's, video footage is there, my lord. Video footage, the rally which were carried out, that has been.
That is
my
why
lord,
I'm asking, on the
recorded.
basis of video, on the basis of the video footage also.
Yes, my lord.
Whether any police also has stated that he is seen in the video footage. He
That-
said
My lord, that is not.
just one
Yes, my
word
lord. That
against him.
that word has not been mentioned, my lord.
See
But on the
that?
basis of that very video footage, the police has identified the accused person, my lord.
Where the police has stated that police, they have identified the accused person in a, where?
My lord, that is,
In a charge sheet, is it there?
my lord, on the basis of which they were arrested, my lord.
Whether the police has stated that in the video footage, this Mr. X is being seen. Has police stated in the charge sheet or anywhere?
That is, my lord, it
See,
is.
then it
is
will be
not here,
difficult.
my-
It will be really difficult.
Even the complainant was examined.
Just a minute.
I'm sorry.
So in, what the police says about the video footage?
Video footage, it's, my lord,
How many names he has taken, the police has taken?
20, total 26.
26.
26.
Police
accused
has
person.
given the name of the present accused also.
Yes.
That is what I'm asking. Kindly show me. Where the police or anyone took the name of the accused person that he is seen participating in the move or in the video footage he has been seen. Unless that is there one name Then see, prima facie, what do we say?
My lord,
What do we mean
there
by
is,
prima facie?
there is no such statement from the police side, my lord.
Oh, then,
But they were arrested on the basis of the video footage, my lord. And
oh, where it is stated that on the basis of the video footage seen, they have been arrested.
And my lord, if my lord, if here is the statement of the accused person, my lord, the statement of the accused person, my lord,
No, forget about the accused person. It is not 164 statement.
not 164 statement.
Forget about accused person. In the charge sheet or anywhere, police or any witnesses has taken the name of the accused person.
It is not there, my lord.
Do you get me when I say that the accused, because 161 is, no, it is not admissible. 161 statement is not admissible. Do you know that?
My lord.
Okay. And then even if the person has given 61, the accused person,
My lord.
he is not going to prove, because it is recorded by the police, not on the spot, at his own only, based on someone's statement, or the person gave a statement and he would go to police station and at his own he used to record. And that is why it is not admissible.
My lord, that part I can understand, my lord. But that part will looking into the in the course of trial only, my lord. But my lord, for the framing of charges, my lord.
That
only
is why I'm
for
saying,
charges,
for
my lord.
framing of charge, at least prima facie,
Yes, my lord.
it has to prove against the accused. What is prima facie?
Prima facie here, my lord, prima facie.
Nobody has stated
Nobody
anything.
stated.
Where is the question of prima facie?
But my lord, one of the accused person has stated about other accused person also, my lord.
Okay, where?
My lord, phrase number 80, my lord. 80 of their petition, my lord.
That is what I am asking. Somebody has taken, if somebody has taken name. Page 80,
Page 80, my lord.
80 of the
Of their
petition.
petition, my lord. Petition, my lord.
Yes. Popita,
Yes, my lord. Popita.
where is?
My lord, the last para, my lord. On the next day, people came from Gandhigram side, numbering around 600 to 500 people with dows and lathis. I and Kuna Yovin, my lord. I and Kuna Yovin is one of the co-accused person, my lord. I and Kuna Yovin of Pojula went with them
This
ferry.
is, okay, this is about Kuna Yovin.
Yes, yes, my lord.
Yes. And then where is the name of the others?
Others, it's not mentioned here. And the team was led by my lord, this Mojasa. Mojasa is the president of all Yovin Student Union.
Mojasa is also the petitioner here.
No, he's not the petitioner here. He's the my lord, one of the accused person, my lord. He is the president of all Yovin Student Union, my lord. And two other persons, Noidu and Wallis, they all are the student leaders.
No, Mr. Kurdu, if you have not gone through the entire record, I can give you some more time. But then unless there is any, there is a prima facie case against the accused person, you cannot frame charge against the person. Because prima facie, what is the prima facie satisfaction? From the face of it, if someone has taken his name, then it is expected that he will come in the court and prove it. But no one has taken his name. What is the point of framing charge against the person where there is no allegation against? Who will identify? Because there is no witnesses who has stated against him till now. Then why to harass him unnecessarily?
My lord, in that case, my lord, matter is fixed on 22nd October, my lord.
Why?
My lord, I will go to reports, my lord.
You go, I think, because there is a name of the accused.
Yes, my lord.
And you have to compare with if there is a name of the accused. And you thought that combinedly there is a statement that they took part. And you thought that they consist the prima facie case. That may not be. So I'm giving an opportunity. So 28, why?
22nd, my lord, since he is also seeking time for
22nd.
22nd,
Yes,
23rd, I have another matter fixed, so it will be a lot, little, if not convenient.
I thought of disposing of this today, because I thought that there is a prima facie case against the accused person.
Even what my learned friend has mentioned, he only say that we too went to the rally fearing persecution. That much only.
And then just go through, make some research. What is prima facie case against? Okay. And then if there is no prima facie case against, no point harassing them. Okay, even as a PP also, a special PP also, if there is nothing against the accused person on record, then no point harassing them. Otherwise, they will claim later on. Okay. Is prayed for by Mr. El Cordo, then special PP, SIT. Let this matter be listed again on 22 September.
October.
October, 22 October.
Obliged.
Obliged. The connected matters,
Up to
14 to 29, madam.
29.
29.
and the petitioner's name also be, Mr.
P. Obin.
B. Robin's
B.
name also be.
P. Dot Y. Obin.
Okay. Yes.
Obliged.
Obliged.
Item number 32.
May I appeal, Lord?
Yes.
My lord, this is application for condemnation of delay, my lord. There is a delay in filing this connected appeal
Okay.
for 13 days.
Okay. Hard, Mr.
Delay may be controlled, my lord.
Hard,
There is
Mr.
a lady.
Let's get the Land Council for the applicant. So this para. This is an application filed under Section 5 of the Limitation Act 1963, read with Section 2 of the Chapter 5A V A of the Guwahati High Court rules for condoning the delay of 13 days in filing the connected appeal.
Appeal, my lord. MSP appeal. Method.
Connected appeal staff. Okay, issue notice. Issue notice. The petitioner shall take steps upon the respondent within a week from today. A respondent by a registered post with AD as well as by usual process within a week from today. List this matter after 4 weeks.
Yes, my lord. On 22.
22.
Yes.
22 October. Okay. 22, I think so many matters are fixed. We'll fix 23. Okay, 23.
Item number 34.
Wait, Your Lord.
Yes, hearing
Yeah, hearing matter now it don't be possible, my lord.
this criminal appeal.
Criminal.
The PP is also present.
Yes.
The conviction of sentencing, sentence of
3 years, 3 years.
3 years for offense.
POXO.
POXO.
So, section 8 also.
Whether, okay. Paperwork is there. That's fine. I don't know. This is for Pasigar.
Pasigar, man.
I don't know. No, this is not Pasigar.
Pasigar.
No, Pasigar.
Today it will be difficult, my lord. If it is not.
It will be difficult only. Just if my name anywhere reflected, I just wanted to see.
No, my lord, I don't think so. It's a new.
Oh, this is new.
I don't know whether when the trial started, but I'm not sure.
Because in some cases,
Recording was done in 2019.
19.
Yes,
No,
right.
no. That is before me. Okay. Then today it will not actually.
Just checking up all of them. Some are in 2021 also, my lord.
That is why.
22
Just a minute.
also.
Yeah.
Page 43, your lordship will find. That is in 21. Another one at page 46,
Okay.
that is in the year 23. 45-22.
Probably no. I think I think I can take up this. Okay, then today it will not be possible. So when do we fix?
It's not inconvenient, day after tomorrow, if it is not inconvenient.
Day after tomorrow?
Yes,
Yes, what do you say? Just a minute, huh? He is inside the custody. He
Yeah, he's in custody.
in execution.
He's in custody. In fact, there's one difficulty, in terms of the POCSO Act, the victim has to be represented. Earlier one,
So a victim is to be represented. No one represented here in this case.
Last occasion,
that is the difficulty. Some private party, they kept on calling and they wanted to, they're saying they're supposed to appear, but
Now then we can, are there any legal aid counsel appointed?
no, I don't think.
LHC lordship, council lordship was appointed, I guess.
Counsel was appointed earlier.
Yes, lordship.
I'm not aware, madam.
Because it was already apprised before the court that this is a POCSO matter.
Now, okay.
Yeah.
Sangeeta Iran. Sorry. So respondent number 2 is represented by Sangeeta Iran.
Sangeet Signal Irang, I think.
Huh?
Signal Irang.
Or S Iran.
S Irang.
Yes.
Yes, Signal
Learned
Irang.
counsel for the respondent number 2. Respondent number 2 is the victim.
Yes.
And then this Iran is, it's only learned counsel, not indicating legal aid counsel, privately engaged.
Or privately engaged.
Appears so.
It appears. So, but unless the.
His name is not shown in the court that,
That's right. It appears. That is why. Yes. I think, okay. Mr. Deepang Ilani, counsel for the appellant, is present. Ms. El Hagelani, additional PP for the state, is also present. No one appears on behalf of the respondent number 2. It appears that the earlier Ms. S. Irang. S. Irang means full name?
Signal Irang lordship. He's the junior of leasing permit, advocate leasing permit junior.
S. Irang. There is other S. Irang also. Only one.
Only one, Signal
Okay,
Irang. He was,
Can't be sure, come on.
S. Irang.
he appeared actually. Now I remember lordship.
Oh, Mr. S. Irang. It's
Yes,
Mr. S. Irang. Appear on behalf of the respondent number 2. However, he is not present today. His name is also not reflected in the course list. Okay. Stop. Para, due to paucity of time, the matter could not be heard. So accordingly, the matter stand adjourned. List this matter again on
Prefer day after tomorrow if it's convenient to your lordship.
25th.
Irang is here in the station.
Yes, lordship. Yeah,
Okay, day
yesterday
after
was there,
tomorrow.
lordship.
Day after tomorrow would be as prayed for. Okay. As it was said, let this matter be listed again on 25 by reflecting name of Mr. S. Irang as counsel for the respondent number 2. Okay.
Problem.
We'll try.
Yes.
Yes. Finish, huh? Okay. No.